I'd like to call the meeting to order, and if we could all stand for the salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, I'd like to take note that all commissioners are here and present today. And the first item on our agenda is going to be selection of a new chair and vice chair. Would somebody like to make a motion?
I would move that the existing chair be reappointed. And
I third it.
You third it? Okay, well, I would like to check with Mr. Laddish because I don't want him to feel any slight at all.
I'm District 2. What can we expect?
You can expect that this chair respects you. That's what you can expect.
Thank you.
So, your feelings, I don't want hurt. Speak up.
Well, if the commission wants you to be a chair, and I think you're a fine chair, I'm not going to register any personal grief. I don't know what's happened to the usual traditions in this county, and I'm much more concerned about what happened in the Board of Supervisors than I am what's happening here.
Yes, I think everybody was a little concerned, but I don't know what tradition is here because while the whole time I've sat here, we kept one chairperson every year, and I'm not making excuses. We need a motion in a second. And, yes, sir, go ahead.
you had a motion and a second.
Oh, was that a motion in a second? I thought it was a suggestion. Okay, well, all in favor say aye.
Aye.
Opposed? Okay, motion carries. And vice chair?
I make a motion to have the current vice chair continue. Mr. Laddish.
Okay, I have a first and a second. All in favor say aye.
Aye.
Okay, opposed? Motion carries.
I would say that previously, the prior chair before the current chair was reappointed after the expiration of the first term, so it's not as if this commission has had a rotating situation.
Okay, I just don't want any hard feelings because I understand where. Pardon me? Right.
Yes, that's right.
Yes, and that was my issue. Okay, so still have an opportunity to throw the gavel then. So is there any agenda changes for today? And thank you all for your support.
No.
Move it.
I like how he takes orders. That was good.
That particular mic, there's one spot it doesn't like.
Okay.
You can have it closer to you or you can have it further away, but that particular spot
We'll see how it does far away.
Okay, I'm going to keep going through this now. Now we're going to go to public comment. Is there any comments from the public that are not on today's agenda?
Good morning, Colleen Platt with MyValleySprings.com, and congratulations on our new chair and vice chair. All of you were qualified, and as was pointed out, that we have had continuing chairs in the past. I believe Suzanne Kuhl was chair for a number of years too, so it's not a rotating thing necessarily. So all of you would have been fine, and I'm sure the two of you will do a good job, and I support this election. Thank you.
Thank you. Any other public comments today? Okay, seeing none, I will close public comment, and there are no consent agendas today. So I guess we will move right into our public hearings unless you have anything you want to say first. Okay, so we're going to go into the first one, which is 2016-191. And Madeline, you will be presenting that?
I am. Can you hear me all right? Good morning. Madeline Flandreau, Planner 2. Today I am presenting the appeal of 2016-191 for Glenn Mallier. On June 17th, 2016, Mr. Mallier submitted an application for outdoor commercial medical cannabis cultivation for 4,900 square feet. Mr. Malier's registration was processed, and on January 26, 2017, he received his certificate of cannabis cultivation registration. All certificates of cannabis cultivation registration expire 12 months from the date of issuance. Therefore, Mr. Malier's certificate of registration expired on January 26, 2018. Now, pursuant to Calaveras County Code 1795165D, the registration can be renewed for an additional year so long as the registrant submits a complete application for renewal to the Planning Department between no less than 30 to no more than 60 calendar days in advance of its expiration date. And as Mr. Malier's expiration date was January 26, 2018, his renewal period was between November 27, 2017 and December 27, 2017. Unfortunately, Mr. Malier came to the Planning Department after December 27, 2017 in an attempt to renew his registration. On that date, planning staff explained that pursuant to the urgency ordinance, he had missed his opportunity to renew, and the certificate of registration would expire on January 26, 2018. We received an appeal letter on January 3rd, 2018, stating that the appellant was not informed of the renewal process, nor was he assisted with the re-registration process, and he could not find any information regarding renewal on the Planning Department's website. He requested in his letter that the Planning Commission take into consideration that he only missed the deadline by a few days, and that the cultivation site had been very compliant and he had worked diligently to follow all the requirements of the urgency ordinance. Although staff sympathizes with Mr. Malier, and ultimately it's the registrant's responsibility to understand all the rules and regulations of Chapter 1795, which he must comply with. And in addition, there's nothing in the urgency ordinance or any other statute that affords the planning director the authority to waive the deadline set forth in 1795165D. And for these reasons, the appellant should not be excused from complying with the requirement that he file a complete application within the time frame stated in 1795165D. And that's my presentation.
Okay, thank you. Mr. Malier, are you here today? Okay.
I have a couple of questions.
Oh, okay, go ahead, I'm sorry.
Does the Planning Commission consider the ban that has been passed by the Board of Supervisors as a permanent ordinance as stated in this section?
Yes,
And
at least the county staff does.
yes, as then under this section, and do you consider that it was adopted as of the time they voted on it? I'm going through the language of the statute.
Yes, that was the date of the adoption, January 10th.
So this section starts off with if a permanent ordinance has not yet been adopted by the county prior to the expiration of a medical cannabis site registration, and then follows with the rest. So here we have the adoption of a permanent ordinance before the expiration. And what is the position of the planning department as far as what we do under those circumstances?
We believe that because of the 90-day period that registrants have to continue to cultivate after the effective date of the ordinance, that renewal for that time period up until that 90-day time period ends is appropriate.
So that if there had been a timely application, you could have renewed before the ordinance was,
Yes.
the permanent ordinance was adopted.
There is some question now if someone whose registration was issued today, or a year ago today, would they be given the opportunity to renew? And we believe that they have 90 days to continue to comply with the provisions of the urgency ordinance. And therefore, anyone that renews in a timely manner would be able to continue to cultivate for that 90-day period.
Yeah, so
And if they need to renew it, even if it's for a month, that's how they retain their approval at the local level so that they can receive a license or maintain a license at the state level.
So, of course, those aren't the facts we have before us now, and we're not going to pass on what would
Yeah.
happen if somebody had requested renewal in time.
Right.
And you were just touching upon what is the result for this licensee of non-renewal?
His registration has expired, and he is no longer registered or allowed to cultivate in Calaveras County.
And I don't know if it's appropriate to ask you, and what effect does that have as to state licenses?
If requested by the state for confirmation that he's allowed to cultivate, we'd have to say, no, his registration is expired, which would preclude his ability to get a state license.
And one last question was, the materials we received from the applicant, or the appellant, were stamped by the Calaveras County Planning Department as received on February 6th. I just wanted to confirm that they weren't received on the 5th.
The additional statement by the applicant,
Yeah.
his date is February 5th, 2018. We received it on February 6th, 2018, yes.
Okay. That's all the questions I have.
Okay. Does anybody have any other questions? Okay, Mr. Malliott, can you please come up? Thank you.
Good morning.
Good morning.
I'm sorry to be here in front of you wasting your time on an issue that I should have taken care of. I recognize it was completely my responsibility to comply with that submittal requirement in a timely manner. All I have to offer is the timing was such that I had a number of things that were pressing on my mind. Foremost being that I was going to be out of business soon if the board adopted a ban or a restrictive ordinance, because I couldn't relocate to another site. So I've invested in my business since I've been approved, and to date I've not received any income from it yet. The importance of having my county registration for me is not the fact that I can continue to cultivate, it's the fact that I need to have that registration valid in order to have a valid state license, which I have. I obtained a temporary state license, but I've been advised that it's no longer valid because my registration at the county level expired. I don't intend to commercially cultivate anymore. However, I have last year's product unsold, and I've invested, maybe not as much as many people, but I've invested all I've had into this business, and I've yet to receive any income from it. And I'm asking you, I'm pleading with you to allow me to reapply, renew my registration so that I can maintain my temporary state license and enter the legal cannabis sales in the state. That's my only intent right now. Again, I recognize it was my mistake. I should have been more diligent reading the requirements of 1795 165D. However, the other factors, the vote of the board that was pending, that was taking all my time. At that point, I was so concerned about losing my business that I simply put this issue off. And when I sat down, I realized I missed it by less than a week. And I immediately came to planning department and asked what I could do. And that's why I'm here today. So I'm just asking for, I guess, a favor be granted. I'd be allowed to continue so that I can recoup some income from the business that I started. Thank you.
So can I ask you a question real quick? What would having a license allow you to do with your current product if you have no way to distribute it out of county? How would that work?
Well, I would have to need to locate a distributor and
Okay.
get the packaging in order. It's the only way that I can sell my product.
Okay. And with that state license, is that transferable, or is that for this county only?
I am not certain of that. I currently don't have any intention to relocate. I've lived in this county most of my life. My roots are here. I don't see moving anywhere. It's possible that might be a consideration in the future. I would have to look at the requirements. I believe that it could be transferred, but I do not know that.
Okay. All right. So the purpose for you doing this then, if you're saying you're not going to grow any further anymore into the future, would be to make your state license valid to sell the product you currently have on hand.
I would like to be able to reinstate my state temporary license or maintain its validity. Right now, I have it. It's listed in the state system, but because I don't have county registration, I don't have a legal state license. And whether I'm going to pursue a permanent state license, I don't know. That's an additional bunch of expenses. I'm not sure if I'm prepared or able to do that. We're in a market right now where the prices have depressed significantly just from last year. So I don't know if I can even make it as a businessman, but I'm going to try to recoup some of my losses if I'm granted the opportunity.
Did you receive a notice of renewal in November of 2000?
I don't recall receiving anything like that.
December, January, no notice. What does the county send out? A renewal?
We did not send out notices of renewal. It was up to the registrant to keep track of their
Not
license.
written that way in the urgency ordinance?
No.
How's it written in the urgency ordinance?
It just says that the registrant may renew or shall renew.
There's nothing on the certificate.
Nothing
The
on the
actual certificate of registration that says anything about this 30-day time period. All it says is that this thing will expire 12 months after the date of issuance. And it also says that registrations shall terminate 90 days after a permanent ordinance takes effect, which, to me, when was the permanent ordinance passed? The one that was just passed?
January 10th.
January 10th. You can interpret this original certificate itself saying he's got 90 days after January 10th.
Well, that statement was to inform all the registrants in the same languages on all of the registration forms that they have to renew within 1 year, and at such time that a permanent ordinance would be adopted, whether it's before that year or after that time frame, they'd have up to 90 days to comply with the provisions of the urgency ordinance, in which, and then at such time, the permanent ordinance, in this case a ban, takes effect.
And I'm just looking at the actual language on this registration, and I don't see it telling anybody that he's got a 30-day time period before the end of the termination. And I also think this other statement that it terminates 90 days after the new one, then extends it from January 10th. Is there anyone else? I'm sorry. I'm supposed to be talking with you. I really have questions of Mr. Maher.
You can ask. That's fine.
Is there anyone else in this situation?
There have been several registrants that failed to
30-day.
meet that 30-day window.
Mr. Mallier, you submitted these materials, the supplemental materials. I think what you said is pretty much what you were saying in your letter. Reason I'm bringing this up is that we got this a day late, these materials. And do you have copies of this? Or we can exercise our discretion to consider them even though they were late, which I'd be happy to do. And I don't know if this came in by email yesterday.
I submitted that to the planning department on Tuesday, I believe.
Yeah, and that's.
Oh, I wrote it.
Anyhow, I'd like to suggest that we exercise our discretion to consider his materials, which are two neighbors saying he's a model neighbor and grower, and his letter that sets forth in some greater detail what he just has stated in his statement.
Did everybody receive those documents and read them? Okay.
I did.
I did too. Okay, so, I mean, as far as accepting them as received, I think all the commissioners have read it. I'm fine with that
That we can-
suggestion.
I've got a question, Mr. Malloy.
Yes, sir.
How were you able to turn to the contents of the urgency ordinance? Is it online? How did you find it?
After going to the planning department web pages and not finding any information, I went back to the ordinance language itself online, and that's when I found out that I had missed my deadline. I would point out it was my responsibility fully, but had I been given some kind of indication on any of the other documents, I would have been down and taken care of it. I looked at my registration. My registration said valid until expires, and I didn't go any further until after expiration when I realized I'd missed my date.
I think you've explained in what you've submitted that on the 20th of November of last year, you realized you would need to check soon about how to renew the registration, and then for other reasons it slipped through the cracks. Is that correct?
That's absolutely right. I failed on that.
Okay.
My understanding is if I'd simply come down to the planning department with my payment, that's about all I would have had to do. I mean, that may be incorrect, but I think it would have been a simple process, I believe.
Do you see, and I'm reaching for straws, do you see anything in the ordinance that gives us the discretion to overlook the requirements?
I am not an expert on that. I had asked Mr. Mauer to consider the issue you brought up with regards to whether a permanent ordinance had been approved. He said he would check with county council, and he told me he didn't have the discretion to waive based on that.
Yeah, and I want to give you a full chance to. I'm coming to a result. I mean, at this point, subject to all the discussion that we're going to have, I'm coming to a result that I don't like, but I think I'm required to do by the law. And that result is that under this ordinance, once a permanent ordinance has been adopted, I'm reading that no renewals could be accepted. If you had applied in a timely manner, you could have been granted your renewal, and then your registration would run until either a year or 90 days after the permanent ordinance was submitted. But I just don't see a way out under the ordinance on how we can treat, obviously, a person that has been a model for what we want to have growers be in this county. From what I can tell, you're with that person.
Thank you.
I don't see any reason how we can give you relief given the language of the ordinance, but I'm waiting to be enlightened by my colleagues. I just wanted to give you a chance to speak to that if there was
Well, if I can respond.
please.
I did act as quickly as I could, and it was before the ordinance was adopted. That's when I first went to planning department, was on January 3rd. Immediately, the same day I realized I had made this business ending error, I went immediately to the planning department.
Mm-hmm.
That was 2 weeks before the ordinance was adopted, or 3.
A week.
And I waited for a response for 3 weeks because the planning staff was very busy at that time.
Commissioner Wooster?
Okay, I'm having a bit of a problem here because I just now understood that you're not intending to cultivate, that you have product that has it been dried? It's ready to sell. All right, now maybe somebody can enlighten me as to what it is in the urgency ordinance that prohibits Mr. Mallier from selling his product.
You have to have a state license for distribution and testing since January 1st. And if he
Okay.
doesn't have the state license, he can't do that.
But I don't see how, he has to have a state license, I understand that. And to have a state license, he has to be in compliance with whatever the rules are in this county.
Correct.
My problem is, and I'm trying to fumble through
see
this,
where you're
now
going.
understanding for the first time what it is that you need. What is it in the urgency ordinance that prohibits him from selling his product? Because the urgency ordinance prohibits cultivation unless you're registered. Cultivation is defined by reference to the Business and Professions Code. And it means any activity involving the planting, growing, harvesting, drying, curing, grading, or trimming of medical cannabis. He's already done all of that. He's not cultivating. And the urgency ordinance prohibits cultivation without a registration. And so I'm having difficulty understanding why it is our ordinance, given his particular circumstances of only needing to sell product that's ready to go, stands in his way.
Because his license was not renewed and paid, the renewal fee was not paid, which terminated his license at the county. And without having that county license in effect, his state license is invalidated. So he can't take the product he can't call a distributor and say, please come get my product, have it tested so that I can put it to market. He doesn't have a license to allow that transaction to take place.
But his registration didn't cover selling product. His registration only covers cultivation.
Commissioner Worcester, I just wanted to make sure that in giving your interpretation of the urgency ordinance, you've looked at 1795160B.
Say that number again.
1795160B. And so whatever interpretation you give the urgency ordinance, I just wanted to make sure you had looked at that section as well.
No, he's not doing any of those.
Well, as a matter of fact, I didn't. But
As I understand it, this is the voice of, no. As I understand it, the hang-up is that the state requires a current registration by the county in order for there to be a state license. And he can't sell it without the state license. And unfortunately, as I understand it, and I haven't looked at the state law, it is a current registration is what's all they're really asking. Is that correct?
Essentially, I think that the point that Commissioner Wooster was trying to get at is valid. If I read 160B, it says we're also prohibiting all the other license types. Well, he's not asking for any of those license types. He's trying to move his product, which requires him to contract with a distributor who then would take that to testing facility, take it to a license retail outlet, all the other things that are required that we have prohibited in this county, but he could contract with someone from out of county to do. The problem is that, if anything, it's just the unique timing associated with when his application was approved and the ability to get the state license based on activity that happened last year legally under his registration, but because it has expired, we're unable to reissue a cultivation license, which is what he needs to have from the state in order to sell his product. Now, there is a possibility that the state, and I don't know this, I'm just sort of speculating at this point, the state could issue a license based on last year's cultivation, understanding that he would be unable to continue to cultivate, he'd be unable to cultivate after 90 days anyway. And I've talked to the head of the Bureau of Cannabis Control about this, because they were at one point not issuing any licenses in Calaveras County because of the ban. And I had to explain to them, no, the ban, one, doesn't go into effect for 30 days, and then those who registered are able to continue to cultivate for the 90-day period. And the real issue, as Mr. Mallier has said, is that the product that was grown last year is what's being sold now, not just for him, but for most people. That's why the price is down. There's a lot of product on the market, but you don't sell it immediately, other than, you know, some of it, most of it is sold, you know, now at this point in time and later throughout the year. You know, I would certainly be willing to work with the state to allow him to get a license to move his product. But again, we're sort of trapped in the language of the code that says we can't renew his registration.
I think that maybe that's the avenue, because we don't want to be stuck with, I mean, this is the classic hard facts can make bad law. I think under the ordinance, he can't be renewed. But if we can make a case to the state that he was fully licensed when this crop was grown, and there were no outstanding compliance problems with that, this crop is legally grown, he just doesn't have a license to cultivate under our ordinance at this point, and whatever use this would be, encourage the state to permit this, to grant a license, a limited license for him to sell his wares.
If I could chime in for just a second, I think Peter is the designated contact person for the state, and all the state really asks him is this person in compliance with local law? They don't even ask if he has a registration. That's what the email says that they send you. Is that correct?
Yes, that's correct.
Yeah. Is he in compliance with local law? Yes or no? Check one.
Well, I think that this 17.95.160B that county councils referred to, if you interpret it to prohibit what he needs to do, it provides too much, because it purports to say that you can't transport the product, period. Irrespective of whether you have a registration. That can't be right.
But you have to remember that transporting is a separate license type under state law. And that's what I think we use, when we define the term transporting, it means having a transport license.
There isn't a separate transport license anymore.
Well, that's true. But for someone to come and pick up his crop and take it to a dispensary or a testing lab or a distributor, that would not be transporting.
Okay, I still am hung up on the problem that I do not understand why he has to have a current registration to cultivate when he's not proposing to cultivate in order to sell his product. So it seems to me that if the state only needs to know whether, from the county standpoint, he is in compliance, as far as I'm concerned, he is in compliance to sell the product that's already been dried, cured, trimmed, ready to go. That's my view of it. And if the commission agrees, then it seems to me the thing to do is to advise the state that for this particular purpose only, he is in compliance.
He is in compliance.
Tell me why I'm wrong about that.
I think that may be the solution. I think for the purposes of today, the appeal is from
You asked a question earlier. Can I interrupt you?
Sure.
Try to answer it.
Yeah.
First of all, I have to do a disclaimer. I've never in my life claimed to know a whole lot about constitutional law. But I do remember two words, due process. And I think this process, this form, the registration form, fails to meet due process for the applicant. It specifically says nothing about this 30-day time limit, and it instead says the registration expires 12 months from the date of issuance, and it further says that registrations will terminate 90 days after the permanent ordinance takes effect. And with that, I think he had plenty of time after the 1 year point to come in, and it came in before. So
I would very strongly resist saying that the notice that's been sent out to everybody that's been granted a permit is a violation of due process. It doesn't mention you have to have it fenced. It doesn't mention you need a grading permit. You know, the ordinance itself, you're granted the permit, the ordinance provides the conditions under which you do, your privilege under that permit can be exercised. And I think where you're going would be, would lead us to a whole lot of situations where people who are not model growers will just say, oh, look, you didn't tell me about no sanitary facilities on this property. You know, the requirements of the ordinance are there. I think it's very unfortunate that Mr. Mallier, you know, just for many reasons didn't meet the requirements. But I think that is not a denial of due process that's in that ordinance. But I think we're on the path to maybe getting a resolution, even though I don't think it would be appropriate for us to grant the appeal and thus have a current registration. I think if the county, I would very much recommend that the county say he is in compliance for the purposes he needs to be, or he is in compliance, has never had any violations that are currently being under.
And I think there's a big difference between the requirements for gates and grading and all that sort of stuff versus a simple time requirement, which is nothing more than an administrative process. So I disagree with you.
Karen?
I agree with your concept of trying to bootstrap him in some other way.
I was just going to say, saying he is in compliance is kind of stretching it. He was in compliance. I don't think to say that he is in compliance, because he's not anymore. He doesn't have a current.
To cultivate. He doesn't have but he's not cultivating. So he isn't violating the statute by cultivating when he doesn't have a registration. Mm-hmm. Everything he has done up to this point has been totally in compliance with the ordinance, as far as we know, and all the indications are.
When did you harvest your?
October.
Thank you.
So I don't think it is a stretch to say that he's in compliance for purposes of the sale of legally produced crop.
I understand. So just for me, I understand what you guys are trying to do and what you're saying, that there's nothing that says he's out of compliance. He just doesn't have a registration, but he should still be able to sell his product. And that's an administrative issue between the county and the state, saying that, you know, he was in compliance when that crop was grown. We're giving him the right to go to sell it. We don't care if he does that. I don't believe that, and this is just my beliefs, I don't believe that I'm in a position to authorize Peter to make decisions and phone calls like that. I think that should come from the Board of Supervisors, because that becomes more of I would rather the Board of Supervisors give Peter that direction and not us. I mean, that's just my personal feelings. we don't get to hire and fire him, but the Board of Supervisors do, and I would want him to get approvals there. This is a pretty big step in setting future cases of those that have not renewed on time. And I believe, Mr. Malliott, it's devastating to see this happen. I think that you're right, Commissioner Wooster, that he should still have the right to sell that product because he was registered, he was in compliance the whole year. He grew it, dried it, ready to sell it. But I don't think that we have the authority to tell Peter, go ahead and call the state and overrule. I just don't feel good with that.
I really don't think it's our role on this appeal to do so, but I don't know what authority Peter would need. We could encourage Peter to do it. All that's before us today is an appeal from the rejection of the renewal.
Right.
And I think my feeling is that there's no other way of reading the ordinance, but that we're going to have to deny the appeal. But I hope that the county and the state can work things out so Mr. Malliott can sell his product.
If I was to rule on anything in here, it would be the fact that we don't send a notice out. That's bothersome to me. I mean, that to me, yes, we could put it in your phone, in your smartphone, in your calendar, and a notice that, oh my gosh, I need to renew. It's been a year.
On the registration.
I get that, but I'm not seeing where, I mean, to me, it's more costs, but they did pay a $5,000 registration fee to cover costs associated with their registration. So that, to me, should have been a built-in cost for notification. Is it in the urgency ordinance properly written? Is it the responsibility of the appellant to have known that he needed to renew, or should the county have at least given a courtesy with their registration fee of a notice? That would be the only thing that irritates me in this whole thing, is notice.
And I imagine the county might be quite sorry that they didn't have such a notice in there, but I don't think it's legally required.
No, I don't think it's legally required. I think as a courtesy with the fees that they paid to cover all costs, then a nexus in tying it all together should play a role in that.
I agree.
I don't see anything inaccurate in the certificate of cannabis cultivation registration. Everything that's stated there is correct.
I know.
The urgency ordinance is quite clear as to what the requirements are, so I don't see a real due process problem here. I don't think I'm in a position to say if I had my druthers, a notice would have been a good thing, probably.
Right.
But it's not required. It's the
Right.
responsibility of the registrants to know it, and I think Mr. Malliott recognizes that. And I don't see a way around denying the appeal on the narrow issue that's put to us.
I don't either.
And I don't think that we have the authority to direct the planning director as to what to do with the state. But it is my sense that he should not be prohibited from selling this product under the terms of the ordinances that we have, for whatever that sense is worth.
I agree.
Okay, so what I'd like to do, Mr. Malliott, unless you have anything else to say, let's kind of go to the public and get public comment on this.
Okay.
Okay.
All I'll be looking for is ultimately what direction, I would need to take, understanding that there's probably going to be a denial of this particular appeal, but there's been some discussion about.
But we haven't really.
I know, I realize it hasn't been
I
decided
just raised
yet.
that.
I understand that, so I'll
Okay,
hold.
we'll give you a second chance if the public says anything to rebuttal that. Okay. Is there any public comment on this?
Good morning, Marty Crane. I just have two questions. I thought I heard him say that he came to planning the first part of January before it expired, and why was he not? Anyway, there's that question, that why it wasn't taken care of then. And then, and he said he waited 3 weeks for a response, but they were really busy. So there seems like there's something, wiggle room there, but also any other business in the county, whether it's has a liquor license or a license to sell garden supplies or clothing or anything like that. When your license is about to expire, do they get a notice? this is just another business in the county. I don't know why it wouldn't be the same. It seems like, that sounds like it was an omission on the county's part. That's all.
Thank you.
Colleen Platt, My Valley Springs. I have two comments to make. One is a comment of sympathy, which will only get you so far, and the other is a comment on the language itself. We did look at the website on the process for renewal of business licenses, and that is very clear. It's very obvious on the website. There's instructions, there's questions and answers posted, and renewal notice is sent out before the license expires. That's a typical process done by the county. That was not done in this situation, and I feel that is a real problem here, and that should have been addressed by the planning department. This has happened before. I've heard that other renewals have not been accepted because of this problem, and it's something I think that could and should have been fixed earlier with a noticing process or a question and answer or some information on the website there. There's nothing on the cannabis page. I searched that page and I searched everything. The only place you can find any information is in the urgency ordinance itself, in that obscure line on that section. So I think that's not fair. But as I said, sympathy and unfairness only get you so far in interpreting an ordinance. So my second point and suggestion is that, as was brought up by a couple of the commissioners, the language of that 17.95165D states, if a permanent ordinance has not yet been adopted, et cetera, et cetera, et cetera. That's not the case here. A permanent ordinance was adopted on January 10th. So this urgency ordinance language does not cover this situation. It doesn't say if a permanent ordinance was adopted, then what happens? It says if a permanent ordinance was not adopted. So that we find ourselves in a situation where the language is unclear, I feel, in this ordinance. It does not prohibit the appellant for renewal of his registration if a permanent ordinance was adopted. There's nothing in there that clearly states that. So it just seems to be there's a gray area. The planning director obviously didn't feel like he had the authority to make a decision there, but the planning commission does have, you can interpret the language of your ordinance there. I believe the appellant did try to renew before the ban was adopted, so there was some discussion about that, and he did try to do what he could do there. And the ban was adopted, so the urgency ordinance section does not exactly address this situation. So I'm encouraging you to find some way to interpret this language to let this person continue to try to renew, which he tried. If it's not accepted, that's fine, but let him continue to go through the process. As you know, it'll expire anyway in 90 days if the ordinance goes into effect, and he just wants to settle his process, sell his product. If he can be in good standing during that time period somehow, then you could help that process. I think that would be helpful here, and not set a precedent because of the timing of his coming into the planning department right before the ban ordinance was passed. The timing of the appeal, this is a narrow focus here that could help. So anyway,
Thank you, Colleen.
Thank you.
But you're walking well.
Yeah, but noisily. Vicki Mills. I went on the website for the Bureau of Cannabis Control and California Department of Food and Agriculture for what they say is local jurisdiction authorization. And they both say this: a copy of valid license permit or other authorization. Seems to me we could come up with some other authorization in this situation, since he's not asking to cultivate, he's just asking to get rid of his product, to recoup some of his investment. And as long as they use the words in both spots, other authorization, I think it would behoove the county.
It's not for you, it's okay. Colleen
I
still
mean, I
has,
thought you
Colleen
liked
let
me.
you borrow her time.
I think it would behoove the county in this situation to come up with some other authorization. Thank you.
Thank you. Is there any other public comment? Okay, seeing none, I will close public comment, bring it back, and do you have any rebuttal you would like to?
I do not. I got a quick comment. When Mr. Laddish earlier raised the issue of statutory interpretation of this particular provision, you indicated we should pass on it because it might not be germane to the resolution of this appeal, but perhaps it is. If you look at the ordinance, it says that if a person applies within that 30 to 60 day time frame, it can be renewed for another year. And there's actually no situation under these facts where it could be renewed for another year. I mean, if you look at it, it says, if a permanent ordinance has not been adopted by the county prior to the expiration of a medical cannabis site registration, the registration can be renewed for an additional year, so long as it goes within the time frame. So the converse of that would be, if a permanent ordinance has been adopted prior to the expiration of a medical cannabis registration, the registration cannot be renewed for another year. And neither of those situations come up under these facts. This person is not trying to renew for another year. And if you read the entire statute, you'd have to X out the additional year part to apply it as we're applying it here. So I don't think it'd be an advisory opinion for the commission to come down on looking at this statute and telling us what it means, because it's probably going to come up in other staff decisions going forward, and it actually is probably germane to the resolution of this particular appeal.
In this situation, though, isn't this the language, if the permanent ordinance has not yet, Y-E-T, not yet been adopted? As of the date he tried to renew it, that had not been adopted at that point. And so the rest of this language, the 30-day thing, just doesn't apply. I don't...
Well, it says not yet been adopted prior to the expiration of his registration. And unbeknownst to him and unbeknownst to all of us, a permanent ordinance was adopted prior to the expiration of his registration. But we didn't know that was going to happen, neither did he when he tried to renew. No one could have known that.
But you're arguing that the 30-day isn't a requirement, because it...
Well, I'm not arguing one way or the other. I'm just saying that there's no facts that have arisen during this appeal that we could apply this language to. I mean, because there's no way he was ever going to get a renewal for an entire year.
But that, I mean, people had gotten renewals, you know, in December and in November and et cetera, and those are not going to go for a year if the ban remains as it is. But really, with the language, since there has been a permanent ordinance and it was adopted prior to the expiration of his registration, there's a condition to renewal. And one condition to that renewal is if a permanent ordinance has not been adopted by the county. And if that condition is satisfied, only then can the registration be renewed.
For a year.
There isn't for a year. I don't have a problem with the for the year. I mean, it's for a year or less, because under the terms of this ordinance that's saying for a year, it provides for that 90-day period, and that it will expire upon the adoption of a permanent ordinance. Not upon the adoption, excuse me, upon the coming into effect of the permanent ordinance. The way I'm reading this ordinance, the main statement in here, the registration can be renewed, is conditioned upon there having been no permanent ordinance yet adopted. And then if that condition is met, if there hadn't been a permanent ordinance that had been adopted before its expiration, then these time periods for the application are an additional condition to this renewal. But I think that the renewal itself is conditioned upon there being no permanent ordinance having been adopted as of the time of its expiration. So that's why I feel that the statute, I wouldn't want these hard facts to lead us to a bad result and then have somebody who does not deserve an endorsement by the county come in and rely on language that I think that if we stretch the ordinance's language, we might end up with bad results in other cases.
Yeah, well, I agree, and I'm really just looking for that. But,
I appreciate that.
The problem that then would follow, and this probably is not germane to this particular appeal, would be if the converse reading is that if a permanent ordinance has been adopted prior to the expiration of the registration cannot be renewed.
I would just ask the commission to stick with the facts of the current appeal.
Yep.
So, just to bring it back a little bit, I just want to, because there were two public commenters that both referenced the same thing. The registration expired in November. The registration notice went, or would have been November, that he needed to renew. He came in January 3rd. He had from November to January to come in. So he was, January 3rd was the date that he came in to renew. The ban went into effect, or was voted on the 9th or 10th. So for me, it's not, the ban isn't the issue for me. It's when his expiration took place and when he came in to renew it. The ban happened after the fact. His appeal is based on the fact that he went to the counter on January 3rd. So that's what we need to keep our focus on, is that at that time, there wasn't a ban. We're looking at, on January 3rd when he went in, he had an expired registration he was trying to renew, and we don't have a provision in the ordinance to renew expired registrations, with or without a ban.
It hadn't been expired. His registration expires January 27th, was it?
It expired January 26th.
26th.
But he didn't come in time to pay that.
He didn't come in during the window of 30 to 60 days prior to that expiration date.
Okay, so it was, I have the date wrong, but he still did not come in time to pay it. The ban wasn't a factor, it was the deadline. Yeah, the deadline.
No, but the ordinance makes it a factor by saying if a permanent ordinance has not been adopted by the county prior to the expiration of a medical cannabis site registration. Here, it was adopted by the county prior to the expiration. So the registration, under the way I'm reading the ordinance, the registration cannot be renewed. You have to have the absence of the adoption of a permanent ordinance in order for the registration
I would
to be
agree with
renewed.
that statement.
Oh, okay.
I think you need to go back to January 3rd. When he acted, he requested the planning department to renew it. On that date, there was no new permanent ordinance. So this 165D does not apply. The 30-day rule does not apply to this particular situation.
That's kind of where I was headed. I wasn't getting it across. That was said well.
But I don't understand.
Had not yet been adopted on
When
that
he came
date.
in on January 3rd.
But that isn't what.
That's the only place you find the 30-day rule, is in this statement, right? Am I right on that?
Yes.
Yes.
It's not anywhere else.
Correct.
It's not in this. It's not on the form. It's not on his application. It's buried someplace in the actual ordinance. And as our public has told us, you go on the website and you just can't find it unless you actually go to the fine print. And so this statement, on the January 3rd date he came in, he should have been renewed.
But the rest of that statement is prior to the expiration of a medical cannabis site registration, so you have to look.
So it was prior to the expiration.
It's prior. Yes,
So-
the permanent ordinance was adopted prior, so this whole first condition is not satisfied.
You're looking at it in today's light. Go back to January 3rd and he met the
That's
rule.
what I was trying to get at. If you go to January 3rd, there was no ban in place.
That's
And he
fully
went
correct.
to renew. Why was
And
he
you-
denied?
Well, in that, if you're just going to look at January 3rd, then you'd say he was denied because he didn't meet the time requirements of the 30 to 60 days.
Exactly.
I think part of the problem here may be the interpretation that says the adoption date was January 10th. I'm not convinced that's correct. If the adoption date is taken to be the effective date, then you don't have a situation where you have a 30-day crack in which you can't apply for renewal if you take the date as January 10th.
But it doesn't come effective until February.
Yeah, so you could have people who would want, who would be in a situation where they want to renew to get the benefit of the 90 days
And to be able to sell their product.
and be able to sell their product. And they're, you know, if his expiration date, well, it is this situation. If you take the position that he could not renew, because looking backwards at it, a permanent ordinance was adopted on January 10th, then you would have to say he would have no ability under this ordinance to renew whatsoever and never did. And that can't be right. If you take the adoption date as the effective date, then that's not true. He would have had the ability and did to renew. Now, it will expire 90 days after the effective date of the permanent ordinance.
But
I don't know that it makes a difference in this case because he just missed the window.
he missed the window, well, the ordinance uses the effective date when it's talking about the 90-day period. And it uses adopted here. And other parts of the ordinance, I mean, not this ordinance, but within the Calaveras County Code, when they talk about adoption, they apparently are talking about the actual passage. Now, I don't think it's too far-fetched, even though it's not fully in accordance with various rules of statutory interpretation, to say, okay, here for this purpose, adopted means expiration date. You know, I mean,
You mean effective date?
Effective date, excuse me. And that, in this case, I don't think it helps this applicant, because then we have...
But if he had made the window...
If he had made the window and had been renewed in December, people who made the window, had the same expiration date, and made the window and were renewed, then their registration wasn't going to be expiring during this time period. They'd be expiring a year from its renewal, or the expiration of the ordinance. So, you know, I don't think it would shock the conscience for us to interpret this as meaning, as adoption meaning expiration date, even though this ordinance uses both of those.
Well,
Effective date, not expiration.
I'm afraid of what effect it might have in other cases we haven't considered all the facts.
Between December 27th and January 3rd, we didn't have a provision for Peter at the counter to renew his license, so we have the lapse. But we do have with what, if we take what Mrs. Mills read into the record on the licensing, that they could still get something from the county to be able to get their product to market without renewing this registration. If Peter were to look at what the state guidelines are, I think that this should be taken to the Board of Supervisors, and they should give Peter direction on how he wants to handle allowing our people to get rid of their product, since they were told grow it, and let them make a decision on a temporary license for them to move their product with the distributor, transport it, and get it out and sold. I think that we should make a recommendation for this to go to the supervisors for them to consider a ruling for Peter and direction.
I think the way to get it to the supervisors is to deny the appeal here.
And let him appeal up on those conditions? Is that the only way to take it to the supervisors, or can we make a recommendation and then let it come back?
We could, I would hate for the facts, and I think Commissioner Lattice has, raised this, the specific facts of this unique case, to look at the broader policy of how we deal with renewals during this window period of the adoption of the ordinance and the effective date and the ability to continue to operate under the terms of the ordinance. We are still sort of discussing that internally, trying to come up with what does this mean for us, and what does this mean for the cultivators, and how does it relate to state law. So I would caution trying to come up with a generalized policy of how we handle this situation when we're dealing with sort of the narrow facts of this appeal. I am quite willing to work with the state to figure out a way that the product that was cultivated while he had a authorization from the county to do so, that he could sell that product and not continue to cultivate. We have other situations where cultivation may be going on right now, in an indoor cultivator, for example, and they need to have the local license to be able to continue to cultivate during this interim period. But in this unique situation, and I'm sure it's not necessarily unique, there's probably a lot of people that do not intend to cultivate this year, but they have product they're trying to sell. That there is a way to be consistent with both the state law and our local codes and allow them to do that without getting too much into a broad interpretation of this specific provision of the ordinance and how it may apply across the board.
Okay, so it brings it back to, I need to allow Mr. Elliott to come back up and rebuttal anything that's just been discussed with us, staff, public.
I don't have anything specific. I may be wrong on what some of the discussion I've heard. I just want to point out I did come back after the ban was adopted and requested to pay, and I was told at that point that after Mr. Maurer discussed it with county council that they couldn't accept the payment after the ban. So I did try before and after, thinking that maybe the language was unclear and I could apply after, but I was given the determination that wouldn't be possible. Thank you.
Thank you. Okay, I'm going to close the hearing, bring it back to the commissioners, keeping in mind that we're voting on whether or not the license expired and if there was a provision in there for renewal. So if there's any further discussion between the commissioners and look at maybe.
Well, if you don't take the adoption date as the effective date, then you may wind up in a situation where just hypothetically assume that he had applied within the window. And then the ordinance is adopted January 10th. And then somebody says, well, the way this ordinance reads, that renewal is no good because you can only get a renewal if the ordinance has not been adopted prior to his expiration date, and it did. That's an absurd result. And so for purposes of this case, it may not be necessary to decide that issue because he did miss the window. But I would point out that the alternative would be to say, well, okay, it was adopted prior to his expiration date, and so there was no provision at all under which it could have been renewed. That is not, in my judgment, the way to approach this. I think we should simply take the position that there was the window, it was available at the time, it was not complied with, and therefore we don't have any choice but to deny this appeal. And then the rest of what we discussed, I think, is really a matter between the planning director, working with the state, and with Mr. Mallier.
To me, this is all really black and white. So I get everything else, but when you read it, he didn't apply in time. Like everybody else before him that we've denied for the same thing, he didn't do it in time.
Commissioner Bocelli?
I've already said my piece.
Okay.
Well, I agree with Commissioner Wooster in that there's a hard question as to whether we can read the word adopted as being the same as become effective. But we do not have to make that decision in this case, because the ultimate condition, assuming that the other conditions of the ordinance were met, the ultimate condition is the timing of the application. And with the danger of making a decision in this case that might affect other cases and facts that we haven't considered, I just want to be on record that if there was a way to read the statute that was a valid way of reading the statute and could give relief directly to Mr. Mallier, I'd be enthusiastically going for that way. I think, however, since either way we read this ordinance is leading to a hard result for him, we might as well stick with the result that he did not satisfy the ultimate condition of the timing of the request for renewal, and deny on that basis.
Okay, thank you. Based on the discussion, can we get a motion, please? Or, and I need a recommendation first.
Staff recommends that the Planning Commission adopt Resolution 2018-009 denying Appeal 2016-191, thereby upholding the Planning Director's rejection of the renewal of Cannabis Cultivation Registration 2016-191.
Thank you.
So moved.
Second.
Okay, all in favor say aye.
Aye.
Opposed?
Nay.
4-1. Peter, you want to read his 15-day appeal period?
So this action is final unless appealed to the Board of Supervisors within 15 calendar days from today's date.
Okay, so let's take a 10-minute break, please. Okay, can we call the meeting back to order, please? And we're going to move on to item number 2, 2016-6002. And Ben, it looks like you're up on this one.
Yes, I am. Before we get started, there were some revisions to the resolution, which I believe were forwarded to everybody. If you did not get a copy, I have some physical copies as well. And due to the breadth of supplemental information that was submitted by the appellant, rather than print copies for the public, it has been made available online with the agenda packet. And with that said, Ben Diamond, planner trainee, presenting Appeal 2016-602 from Taulai by Tulala, appealing the denial of commercial medical cannabis cultivation registration application 2016-602 by the planning director. To my location slide first. This parcel is located about 1.3 miles north of the intersection of Walker Trail Road and Hogan Dam Road. And it is a 535-acre parcel that is appearingly split in two, but it is one legal parcel. It just has multiple APNs due to being split by tax assessor lines and being in multiple books. So that is the subject parcel that we'll be considering. This application was denied for failing to meet the setback requirements of the urgency ordinance, camping in excess of what is permitted by county code, failing to meet the sanitation, health, and safety requirements, specifically how they apply to agricultural workers, and failure to comply with other state, federal, or local laws on this parcel, as well as others under the lawful possession of the appellant. Start with the setbacks. Parcel 42 is the registered parcel. All aerial imagery suggests that the cultivation site, circled in red there for 602, is located on the parcel directly below it. And this is supported by a letter from Barnett Environmental, the environmental consultants hired by the appellant for their water board compliance, which states cultivation site 13 is located on the property line between parcels 41 and 42. And site 13 is the cultivation area for this application. So it is either not on the parcel at all or intersected by a property line, and in either case does not meet the requirements for being set back from a property line of 75 feet. While out serving civil abatement warrants and then later a criminal warrant on this parcel, as well as the other parcels that the appellant had, the sheriff's office identified at least 2 open-air campsites within the immediate vicinity of the cultivation area. As you can see, one of them here is just a mattress on top of some pallets, and from the appearance, it looks that it's been used in excess of the 14 days permitted by county code. There was another campsite identified during the serving of the warrants, but pictures were not provided of it. And the housing, sanitation, and health of agricultural workers. State law requires that drinking water, a restroom, as well as hand washing facilities be within a quarter mile of where hand labor is occurring, which you can argue the picking and trimming and other assorted cultivation activities involved are hand labor, therefore should be within a quarter mile at least of the cultivation area. This is a photo taken by the sheriff's office while they were serving the abatement warrants. And as you can see, there is a little bit in the way of infrastructure at the cultivation area next to the blue truck there. There's a lockbox, a plastic tote, and what appears to be a plastic 55-gallon drum. The lockbox and tote were for containing protective equipment, fertilizer, stuff of that nature, but as you can see, there is no restroom within the immediate area, and based on the materials for the appellant's other applications, the nearest restroom is on parcel 41, and that is well over a quarter mile away from the cultivation area and is likely in excess of a 5-minute walk, as well as the state law requires it to be within a quarter mile or 5-minute walk, whichever is shorter. And this is all supported by the appellant's appeal letter, which also states that the nearest restroom for this cultivation area is on parcel 41. While out serving the abatement warrants, the sheriff's office also identified water diversion occurring on the stream that runs the boundary of the parcel. It led toward the cultivation area for 602, and the appellant failed to notify Fish and Game of this diversion, which is a violation of state law. As you can see here, this is a photo taken during the abatements. There is a water line running directly to the grow area for 602. And regardless of whether or not it actually went all the way to the cultivation area, this was a diversion, and it was occurring on the parcel while under the lawful possession of the appellant. So it is a violation that would meet grounds for invalidation under 1795, 170A2, which is the violation of other federal, local, or state laws. And here you can see the line continuing up the creek. There's some water spraying out of it, so even if it is not being pumped, there is some sort of positive pressure maintained in the line, so the diversion was still actively occurring when the sheriff's office found it. And just in closing, the appellant had two other applications, 2016-601, 603. Both of these were denied based on multiple violations of state and local law, and based on the most current lease the appellant has provided in their application packet. They had lawful possession of the entirety of all the parcels that 602, 601, and 603 were registered for. And based on the violations that those other applications were denied on, other violations of state, federal, or local law were occurring on parcels under the possession of the applicant, which meets grounds for invalidation under 1795-170A2.
In some of the supplemental materials provided by appellant, there's a management plan dated December 12th, 2017, and it's showing a site that's clearly on the parcel. Do you understand how that relates to what you presented?
It is difficult to understand the maps provided in that supplemental information because they were also made by Barnett Environmental, the environmental consultant hired by the appellant, which clearly states in its letters to the water board and to the planning department that this cultivation area is being bisected by the property lines and is not located on the subject parcel in its entirety or somewhat partially. And if you go back to the aerial imagery, it's sort of difficult to see. You can see a smaller cleared area directly above what became the cultivation area. That's where it was previously located in 2015, and that's the cultivation area 13 that Barnett commonly refers to, and it's unclear why they say it's entirely on parcel 42 because all available information puts it between the two parcels or on parcel 41 entirely.
And we're not, as part of this denial, you're not alleging unpermitted hoop houses or unpermitted grading, is that correct?
No, the application was previously denied for grading, but based on other decisions by the commission, that denial was rescinded.
Yeah. So those issues are not before us?
No.
Thank you.
A couple of questions. Were the planning commission decisions on those two other applications appealed to the Board of Supervisors?
They were not.
With respect to the water diversion, is there evidence that there was a substantial diversion of water?
The degree that the water diversion was occurring does appear substantial, as it not only went to this site but went off towards other of the non-registered sites that were on the other parcels.
Do we have any information as to what percentage or fraction of the flow of this creek was diverted?
We do not.
So, none of the water diversions were going to a registered grow, only non-registereds.
One was, at least one was leading directly towards 602. It appears from some of the supplemental information that the appellant has provided that it did not go all the way to 602, but it does not have to go all the way to a grow site to be a diversion. Merely impeding the flow of the stream is a diversion in and of itself.
But none of the water was feeding any of the grows.
It was not being fed directly to the grows. It does not do
Okay,
that.
thank you.
And you talk about a criminal warrant, but that criminal warrant, did it specifically name this applicant?
I'm not certain of the specifics of the criminal warrant. They sought that while they were serving the civil abatement warrant, and due to the violations they identified while serving that warrant, they requested the criminal search warrant.
And the civil abatement warrant didn't involve this grow particularly?
It involved the illegal or unregistered cultivation sites on this parcel as well as the other parcels that were registered. As you can see, the upper parcel does have a couple up in the upper right portion there, some unregistered grow sites.
The picture you showed us showing the limited infrastructure, abatement was happening at that point, and that's on this grow, right?
Yes.
And what was the grounds for that abatement?
I assume it was likely because this cultivation site being on parcel 41 would put the registration for parcel 41 significantly over canopy, and it was likely identified as one of the unregistered grow sites.
Likely identified? It was identified, or?
As it was abated, I assume it was.
The county code enforcement got abatement warrants, civil abatement warrants for all of the unregistered grow sites that were on the site. In communications with the registrant, code enforcement officer Sabrina Cable, talked with them. They said they were unrelated to their grow, and so we went ahead and cited them as being violations, as being nuisances. And we went to the hearing officer, got a abatement warrant, went to the court, got it signed off, and then did a civil abatement of all the surrounding grow sites that were unregistered. This grow site was in the middle of those, and while the sheriff was providing security to code enforcement officers and the contractors performing the abatement, they observed activity which they thought was criminal in nature, and Sergeant Crabtree went back and got a search warrant, a criminal search warrant for this site, and then confiscated all of the cannabis, presumably preserving some for evidence.
Okay, thank you. Are there any further questions, or would you like to hear from the appellant?
Hear from the appellant.
Okay. Good morning.
Good morning. If you don't mind, I'll just take a couple minutes to set up.
You want to put the clock on?
Right now.
No, I'll let her set up.
Where would you like me to set this? Is this okay? Sorry, wires all over the place.
Did she prearrange to set up?
I timed this. I might be a couple minutes over. I just wanted
Okay.
to.
And I'm sure we'll have questions, so go ahead.
Let me. Hopefully. And my mouse is not working.
Sorry about that.
Let's see.
Oh, would that be okay? Oh, you're the best.
I'm so sorry. Oh. Good morning, honorable and distinguished commissioners. Thank you so very much for your time. My name is Tawalai Vaitulala, and I'm here concerning my registration 602. This is my farm. It's comprised of 1,047 acres. We have parcel 39, parcel 41, and parcel 42. Parcel 41 was denied. It was rescinded. Parcel 42 denied, and it was rescinded. Here we have parcel 41, which was denied, and parcel 39 denied. So both of those two bottom ones were denied. December 14th, I went to a denial hearing, and both of those have been denied. I am no longer able to cultivate on those parcels, which leaves parcel 42, which will encompass essentially the whole 1,047 acres of land.
So parcel 42 is the 1,000 acres?
No, parcel 42 is
You're encompassing
535,
all-
yes.
okay,
I'm
535,
essentially.
okay.
So after my denial, December 14th, the next day I woke up and I just, let's try to recoup and salvage at least my last registration. I have children and I'm a fixer. That's what I do. You have a problem, mommy's gonna fix it. And so this is what I did. In my mind, my flow chart started. I started to think, what can I do to make things better? How can I make this right? So I started to formulate my action plan, get my strategy down. And with contacting all the various departments with regards to making this right, yes, the water diversion was not mine. It was a previous grower in 2015. I contacted the Regional Water Quality Board, the Department of Fish and Wildlife, where you have the email thread that I had with him. And he said, yes, by all means, based on the pictures that the sheriff's office provided, please pull the piping. Pull whatever hand pumps you can find, and let's let it go back to its normal state. Well, fine, let's do it. I've contacted the Calaveras County Planning Department, the Building Department, the Department of Agriculture, the Calaveras County Sheriff's Department, the Department of Environmental Health, Calaveras County Code Compliance, Calaveras County Public Works. So in an effort to make things right and let you see what I'm capable of, this was my step process. These beautiful pictures are at my ranch, and they're just breathtaking. And this is what I want to preserve, what I want to make right. So let's begin with 602. In the upper left-hand corner, you'll see what I had to deal with upon securing the lease of property. A lot of piping from the previous grows. If you were to go onto Google Earth, you'll see some of the previous grows which were done, which were not mine, in 2015, and these were some of the items I had to pull and clean. So on 602, the middle picture where there are two pipes that veer off, I suspect, I'm no water diversion expert, but I suspect from one of those pipes it would lead to the east in the red box, the eastern parcels which were used as a previous grow. I hiked up 4 hours. It was amazing. I had such a great time. It was fun. And my trusted comrade there, we just had a great time hiking up, but it was a lot of work. We would pull up tons and tons of piping, trail it down to make sure that all of the piping was mitigated. And we pulled over 1,500 feet of piping. In fact, I feel maybe I'll donate my time to the county to eradicate any guerrilla grows for water diversion for free, because this is what I believe in, is the environment. My neighbor Ken Johnson's side of Bear Creek, that's the middle picture on the left, all of that piping was pulled, yet on the land side, it didn't lead to any gardens, so which I found pretty odd, but I consider that a dead pipe. Here was another pipe. It was rather obscure, leading from 601 to 603, where the red arrow is at the bottom. This is where it may have fed a previous grow. But this is what I'm dealing with on a vast, huge property, over 1,000 acres. We have 3 wells on the property, one on 41, which pumps 40 to 50 gallons per minute, one on 39, which we use seasonally between April and July for 601 only, and we have one near the corral that was collapsed, but we were advised to allow it to settle, and then we should be able to re-drill it and have it be a good provider. Specifically on 602, which is my last registration, the tote that Ben was referencing is my PPE. I work closely with the Department of Agriculture. Just wanted to make sure any OSHA standards are covered, everyone's safe and secure. So I had my PPE, which included an eye wash station, a pesticide suit, 10 mil gloves, safety goggles, a first aid kit, 3 gallons of water, an employee manual with the exact location of where they are, should there be an emergency, the nearest hospital, MSDS sheets for all products used, Department of Agriculture pesticide application sheets, a fire hydrant, pesticide storage lockbox, which is required by the Department of Agriculture. All pesticides have to be locked. A pesticide safety information manual, a water receptacle with single-use cups, portable restroom equipped with soap, hand washing station, and single-use towels. The bottom left, my hope is to have available an AED unit on site, which is an automated external defibrillator in case of emergencies. The porta potty available, by which I do get a weekly clean out, is of course the toilet portion, urinal, and hand washing station with single-use towels. And this is what I have available on 602. All of the items in the bold were actually available there on site throughout my harvest time. What I failed to do was the water receptacle and the portable toilet, which was available on 41, not knowing that it had to be a 5-minute walk, which I've walked it before, and it's not that far. But whatever is needed and required, I will make sure of it. Some of the various projects that I've done to clean up the ranch, of which some of these pictures you might remember from my previous denials. We have before and after for the eating area on 41, totally cleaned. The 2 tents in question on both 601 and 603 have been totally disassembled. And it's amazing how just through the process, now the building department does not accept hoop houses. So if I were to erect such tent, I would need engineered stamped plans, and there would have to be a special footing applied, just things to follow, and I'll definitely keep that in mind with regards to following the right process. Here we have on 41 the portable toilet. I did add a hand washing station and a water receptacle with single-use cups. The metal barn, which was on 39 or 601, it's been totally cleaned out. And on the sheriff's report, which I actually never saw this site, it was they called it a fertilizer site. And after searching through the property, because you had to go really deep west on parcel 39, I looked at it, I was like, wow, this is interesting, because there were nutrients and fertilizer that I would never use in my garden. No sleeping area, piping, little T-tags that I will never use. So I just found that interesting. What I'm thinking is it may have been a soon-to-be Gorilla Grow that just didn't take shape. Maybe they saw all of the movement on my location and they just decided to leave. Yes, I found that very interesting. But that site has been cleaned up as well. Some more projects which I had completed on the site. There was a tent with more bedding that was cleaned up. Yes, I do drive a Bobcat. I drive a forklift. I'm also a welder. I drive an FMC loader. I drive a belt loader. I drive just about everything. But these were the gardens, previous gardens that were totally taken back to its natural state. Before and afters from these different projects. In terms of the open defecation, and this is my 11-year-old son, tell me why he's smiling as he's picking up toilet paper, but that's okay. I instill hard work in my children, and they realize we have to bring nature back to its natural form. So this was a before and after of what's called a cauliflower patch. On 602, the Sheriff's Office report referenced a human waste area. I combed this area up and down, back and forth, and I did not find. There was no evidence of open defecation. 603 as well. But I was in contact with the Fish and Wildlife regional representative for Calaveras County, worked closely with him for all water diversion and questions about open defecation. Which leads me to the illegal grow on the hill. This is parcel 41, or the denial for 603. And I cleaned it. You have to do this. Why wouldn't you do this for nature, whether you were the cause of it or not, which I was not? We pulled the piping, picked up trash. What was interesting is they did a 4-stick support system for their plants. Every plant up top had that, and I'm surprised there was no picture of that in the sheriff's report. So, and I retrieved all of these 2x2 sticks on the lower right-hand side, and I just wanted to show just a comparison. For my 3 grows, I use corrugated metal tree skirts. The middle picture, it's kind of hard to see, I apologize, for all of my 3 grows. What was found on the hill was this 4-stick support system. I tried to recreate it in that I couldn't get there in time to take a picture post-abatement. I already had helpers start to pull the sticks. But my question is, if you were the only grower for said property, would you utilize 2 different techniques or strategies to grow? I would never do the 4-stick support system. I use the corrugated metal tree skirts. So I just wanted to preface that. Again, there was more water diversion in the illegal grow site up on the hill. I pulled 700 feet of piping. Of course, it's all stored properly. I did contact the building department, who referred my question to code compliance, and Courtney did get back to me. I have what's called like a little storage area. If an item could be recycled, reused, repurposed, I wanted to store it properly and make sure that we're not hurting the environment. Environmental health sent me to building department sent me to code compliance. And Courtney did give me a couple of tips with regards to proper storage, something to alleviate any rodents. So that definitely I will follow. The illegal grow on the hill, every location had these state certificates. This is a typical state 99 plant certificate. And these were available on each and every site. I'm surprised the sheriff's office didn't pull them down. I don't know if these people were contacted to ask them, hey, who may have had access to your certificate? But they were still there when I cleaned up. I pulled them all down. But I just wanted to give you an example that this is what was there, this is what was found. Which leads me to my day of abatement. I have a couple of questions for the sheriff's office. Was there any aerial footage of me ever being on the hill where the illegal grow was? Any photographs? With my background check completed in August, am I a threat to society? I held a federal clearance for 26 years. I was invited to the White House 3 times a year and had access to the U.S. Capitol, House of Representatives floor for 24 hours a day. I was FAA cleared for 2 years. I'm fingerprinted at my children's school. I'm currently a Cub Scout volunteer. My position is committee chair. I have completed 135 hours of real estate school. I'm an aspiring California realtor, and I was fingerprinted. I also held real estate licenses in 2 other states, Virginia and Nevada, for all of which I was fingerprinted. October 4th, I went to the ranch knowing that there was a citation served and posted for the illegal grows. I had guns drawn on me twice. They shut my ranch down. I was not allowed to enter for 2 days. They served an abatement warrant, found other violations, and were waiting for a criminal search warrant. Yet they had already searched my property and told me all that they found before a search warrant was obtained. Sergeant Crabtree was my point of contact. He was very nice, cordial, comforting during this time. When he said he was going to cut down everything, there was nothing I could do. I wasn't allowed to share my side of it or speak to the judge. My 3 sites were taken, gone, all of my hard work destroyed. On October 5th, I was there every day as a diligent registrant that I am. After the abatement team left, Sergeant Crabtree assured me, let's sit down, have a cup of coffee, so I can ask you some questions. I was very happy that someone was willing to hear my side of it. He said, I'll write the sheriff's office report in a way that you'll be able to keep your registration and continue to grow. He said the Planning Commission allowed a registered grower with a butane lab to continue to grow. I'm sure they'll allow you. This is where my phone calls to Sergeant Crabtree went unanswered for 32 days. The arrows in the red show how many times I called and left messages on Sergeant Crabtree's phone, voicemail. I also called the sheriff's office, the main line, and they said to me, who are you working with? Sergeant Crabtree. So to his voicemail, I went. The communication through the sheriff's office was non-existent, which led me to my denial process. Sergeant Crabtree also told me there were trash bags full of processed cannabis stashed on top of the hill. If there was collusion involved, wouldn't all cannabis be in one general area? For code compliance, since they've observed so many sites, big and small, have they ever seen stark differences in growing techniques found on one site? I don't use a 4-stick support system. If I were responsible for the whole site grow, wouldn't you think I would use the same technique all the way through? I'll say this till I die. That was not my grow. Miguel made a comment during my last denial that it was his first time he heard about this state 99 licensing grow. Please read my first appeal letter for 41. It reads, I'm unsure what agreement the landlord has with the occupant. Then, of course, seeing the certificates on Google Earth, Google did an update late September. I could see, wow, you could see right there, the certificates were there. I was never able to see how extensive this grow on the hill was until Miguel showed me the picture to sign and say that, yes, that is my site. From the day of my first denial, I have been upfront with the planning department throughout this process. Code compliance staff considers it odd when they issue the citation for the illegal grows that I didn't allow them to view my sites. Have you ever invited someone to your home while you know it needs some tidying up? No, you invite them when you know it's presentable. Code compliance staff also wrote reports on September 12th and September 29th. In her report, there was no mention at all of it being odd that the registered grower did not allow her to view the property. My responsibility with all the local ordinances followed, county rules, regulations to abide by, were all my concern for my 3 legal sites. At the code compliance hearing before my abatement, which occurred on the 29th of September, someone did show up regarding the illegal grow, the citation. Correct? It wasn't me. I was not the responsible party. Planning Commission staff quoted, they said, you had 3 legal grow sites. Why would you want to grow illegally on your property? My reply, on the contrary, I have 3 legal grow sites Why would I grow illegally and put at stake all the work I've done, my name and reputation? The landlord had the citation in his hand. What he did with it is up to him. My site is always clean. There was no camping allowed. My manager made sure of that. It reminds me of a saying, when the cat is away, the mouse shall play. And they played on my property while my manager was away. As stated in my previous denial hearing, my manager left to accompany his fiancée to Texas to be with her father, who subsequently died a few months later. With no vested interest in my passion, my work for the past 2 years, it was hard to cope after getting abated. I wish my former manager were here. I just couldn't afford to keep him on with no work available. He lives out of state. In my last denials, I was so embarrassed how the carrying on my farm went. Murphy's Law. But now I know better. I've learned. I also say learning experiences are expensive. This is what happens when someone tells me no, especially when I know I'm not the one at fault. I stand up for myself. I don't mean to be rash, but I'm fighting for what I know, what I believe, what's right. Inasmuch as planning department staff may want to run me out of the cannabis business, I'm sorry, but I'm here to stay. Of all the different facets of this industry, transport, distribution, manufacturing, lab testing, my love and passion is cultivating. I can't keep any other plant alive to save me, but this plant responds to me. I'd prefer to be outdoors in my garden than be behind a desk. My neighbor Ken Johnson, who was here for the last 2 denials, spoke against my holding a cannabis registration. I have since made amends with him. We talked it over, and he sent an email to the planning department regarding my being his neighbor and supportive should the planning commission uphold my appeal. On this particular picture, slide, you see, of course, on the left, the phone calls that went unanswered by Sergeant Crabtree, my point of contact. When he did finally call me back, November 6th, that was 32 days post-abatement, and he said he was in training. Then the first memo from the sheriff's office was produced on the 16th of October, and then the sheriff's report was both produced on the 21st and the 15th. So here on the far right, I just found it kind of interesting where information was stamped into my file in the planning department, yet I was not privy to the information until the day the staff report came out. So these are some of the days, number of days as to how long the the planning department had this information. It was stamped into my file, and no one sent me anything. So they held on to the sheriff's office reports for 11 days, 11 business days. My most recent one for 602 was 11 days. 603, they held on to that for 18 business days. There has to be a better line of communication for a win-win situation between farmer and planning department, or just having us understand what's in our file. Whether it be like a medical, they use it in medical offices now, a patient portal where they're sent an email, Save a Tree, they're sent an email, and it's up to the farmer to log in to see what new information is in their file. Through the course of my denial, my last denial in December, I looked through an email thread which was written to my neighbor, Ken Johnson, in that there were some comments made by the planning department staff. And some of these comments I felt I was being cited. They were very biased. I'll just reiterate them for the record. I've seen many projects with violations of our urgency ordinance over the last year. Only one other can I think of that may rise to this level of incompetence in keeping up with the requirements of the urgency ordinance. I guess that's lucky for the county, but unfortunate for you, in that this registrant is trespassing on your beautiful property and abusing its resources. This is very bothersome. I'm objectively hopeful that the Planning Commission will reject the appeal and the registrant will be put out of the cannabis business. Regardless, I and all those in all county departments who have dealt with this registrant appreciate you stepping forward and providing this information. And this was when I thought, am I going to get a fair hearing? Does everyone think this is how I am and who I am? The incompetence of which I didn't do water diversion. That was not my doing.
Excuse me, I just want to inform the commission that it's gone way beyond the 15 minutes. And there was a problem with the buzzer, so.
Okay, thank you.
In closing, the choice is yours, planning commissioners. Look at all the evidence presented and the new evidence that has come to light. With my track record, my willingness to follow all rules, my making all hard deadlines, please trust my capabilities to be a stellar cannabis farmer. I feel great that the property is fully cleaned, the waterways are back to normal, we can move on. I have full control of the property. I need you to believe in me. I am the high standard you are looking for in this community. Thank you for your consideration.
Thank you. Do you want to go ahead and take down your stuff and?
Yes.
Yeah, and that way we can. Is anybody going to have any questions that she posted on her computer?
I have questions, but we don't need her computer.
Okay, all right. So we'll have you step back. That way we can get Ethan and Benjamin back. Thank you. Go ahead.
Okay. With respect to the property line issue, there is a letter of June 27th of 2016 from Barnett Environmental that says that this site is located on the property line between parcels 41 and 42. And then there's a map that's submitted with your recent submission on page 39 that seems to show the same thing. And then there's an email from you to Peter Maurer of January 29 of this year that says that the surveyor did measure the bottom of the parcel line for 42. We measured for sure and are more than 100 feet from this parcel line. So my question is this site, which parcel is this site on? Or is it on the property line?
This site, so when I started my application process, trying to find an environmentalist was beyond, you had to search high and low to see if people were going to come out and help you. And Barnett was the one who was available and able to help me. You'll find in everything that, I have copies of my site management plan if you would like to view them. They have some fold out. I only have 4, sorry. But he was there with his Tumblr GPS. He measured everything. I pay professionals so that they can provide me all of the information needed to move forward so I can focus on another aspect of it. And this is what he came up with. He did all the maps and plans. In the first denial for 42, he provided another map, which had that parcel there as well. To answer your question, Commissioner Wooster, I was unaware, I'm just trying to brainstorm and see how can things be fixed, whether it's yay or nay, or, I watched a previous hearing in that there was a lot line adjustment that could have been an idea. I'm like, okay, let's research a lot line adjustment. What does it take? What does it do? How can it be done? And I'm just trying to collect information. And from what I was told, there was a marker, and then it was measured from the 42, the bottom of 42, to the tip of the grow site. And I did not do that personally. It was actually one of my workers, but this is what he was told. Although when this was actually done, I did speak with the surveyor. See, Barnett and the surveyor were supposed to work together and make sure everything's done. And this is what Barnett told me, and I just went with it to go to the next step. You know, what other certifications do I need? What other departments do I have to contact to ensure that I'm doing everything correctly? I just actually contacted the surveyor. I managed to nail him down, Motherlode Engineering, a local surveyor, great guy to work with. And he just did a look-see based on the county overlay. When I spoke with Public Works, just researching more about a lot line adjustment, trying to understand the process, what does it take, what's the timeline, how much would it cost, that type of thing. They did state that, you know, whatever the county has online is merely an overlay. You cannot use that for surveying purposes. And I was like, okay, I'm just trying to understand the whole mechanism. And, you know, I have to wear so many different hats doing this business, and I never thought I'd have to wear so many hats: surveying, lawyer, environmentalist, Department of Agriculture, and really all I want to do is cultivate and grow. But anyway, back to, yes. So I did speak with my surveyor, finally got a hold of him, and he looked at what the county has online in terms of the overlay, and he followed it. He did not go physically to look for the marker, but he followed it just based on, I guess, something similar to this, and followed it. And he says, from what it looks like, that line is above the grow, making what Barnett produced incorrect. But the surveyor was not physically there to actually, you know.
When you say that line was above the grow.
Yes, so in other words.
Would that put your site on 41 or 42?
That would be on 41, yes, sir. So this is when I was like, okay, just a couple days ago, and my email with Peter Maurer was just to try to get more information, like how does this work, the mechanisms, what's needed. Thank you, I appreciate that, Ben. So yes.
So if I understand this correctly, if Barnett is correct, this cultivation area is bisected by the property line, and if what your surveyor was able to find out is correct, it's entirely on 41, not on 42.
That is correct, but I was going off of what I paid a professional to do, which I have been working with him for 2 years. Okay. He sent the water board application out. The water board didn't see any red flags, so this is where I am, and I'm just trying to pick up the pieces.
Okay, now on the water diversion issue, the sheriff's office supplied photos of water diversions on this parcel from a creek, and one shows a pipe headed, according to the sheriff's office, straight for this grow, and that was, I think, on October 5th of last year. And my question is, where did that pipe lead to? Where did it wind up?
In the packet, you'll see for my previous denial, 442, Barnett drew a picture which piggybacks where the 2015 grow was. And this was when we went through that denial for the water board. You know, why did you move the site? We did not move the site. We made it water board compliant. So this was the gist of the first denial on this parcel. And with that, the old version, can you click back to 2015? The old overlay of 2015, you'll see that it is closer to the waterway. Were they given the packet?
But I'm still not clear on where that pipe went.
Yes, it did not go to my site. It was too short. It didn't fully extend. So it went to the 2015 grow. That pipe's been there since 2015.
Well, who had the 2015 grow?
You would have to ask the landlord.
It wasn't you?
No, sir. I didn't take lease of the property till 2016.
The letter submitted by Barnett says that you were growing prior to October 2 of 2015. Is that correct?
In actuality, the 2015 grower was gone. I saw this as an opportunity to piggyback on another grower who was there previously and still be able to use the location and use it for my legal application.
So when did you start cultivating on this site?
2016, yes, sir. That's when you see the pictures where
16?
Yes, sir. When you clean up 2015, that's when my stint started.
And you continue to cultivate at the same area that the previous grower had cultivated?
That is correct, because you would be grandfathered in for the Water Quality Control Board. Your site had to have been in since October 2015, which that site was definitely allocated and done, but my lease did not, wasn't into fruition until 2016.
So is it your understanding this pipe went to the previous grow? In
that is correct, yes, sir.
Okay, and if you were growing at the same place in 2016, wouldn't the pipe have gone there too?
No, sir, because I had already, Jim moved the site over. In fact, I didn't even know the pipe was there.
So you moved the site from where it was in 2015 to a different location?
No, sir. To make it water board certified, and you'll see the different shapes of it. Do you have those pictures, the between 2016 and 2017? Okay. Yes, so no, the water diversion I did not use, ever. In fact, I didn't know it was there. Yeah, the property is so vast. I should have been more diligent in climbing, 1,500 feet worth of and exploring more. I just didn't have the time. I was busy cultivating and readying and preparing locations.
There's been a lot of evidence and discussion about these other grows that were not yours on the property. And you did have a lease, though, that covered the whole 1,000+ acres starting in 2016. And so why was it that you couldn't go to the landlord and say, I've got the lease on this whole property, I want these other folks out of here, or go to the sheriff's department and say, there's some people here growing on my leased ground that don't belong there, would you please shut them down? And that didn't happen, correct?
I did voice my opinion, and what I was told was, this is a state 99 location, don't worry about it. This is what I was told by the landlord.
Did you contact the sheriff's department?
I should have, and I should have.
But you did not?
I would have preferred to drive a D9 and destroy everything, but yes.
So what you're saying is, even though you may have a legal right to get rid of these other grows, as a practical matter, you felt that you could not?
This is where, if you have a lease of a property, do you actually have full control of the property?
Yes. Yes.
In some cases, no.
Correct me if I'm wrong, but isn't your lease with the property with your brother-in-law?
That is correct. He is the landlord.
Can I ask a question on that line of the lease? I've heard 2016 is your lease, but the one I see says January 1st of 17. This is attachment 6 to our package, which says August 8th of 2017. When did your lease actually start?
It was, that's actually the renewal. So you would have to go through the other packet, sorry.
Well, in any event, the one that is dated January 1 of 17 refers to all 3 parcels. In fact, it uses the word all. You're releasing all of the following parcels, 42, 41, and 39. Paragraph 4, acceptance in the present condition. Tenant has inspected the premises and accepts the premises in their present condition. And then further on, it says you have the right or the duty to maintain it. That's pretty clear. Sorry, I just wanted to clarify the lease issue.
When I went through the denial process, and Miguel said, hey, you're over canopy. I'm like, no, I'm not. That is an illegal grow on the hill. And he says, well, you need to bring your site into compliance. I was like, okay, you're going to make me go and tell the people with whom I don't know, am unaware of, that they need to cut their stuff down. And he says, well, you shouldn't have to put the law into your own hands. It's okay, I'll send code compliance, which is what he did. They were issued the citation. Now, so from that point on, it was not my responsibility in terms of, that was not my grow.
With respect to the camping, our file has pictures taken that appear to show at least 2 camping sites on this parcel. And I think I heard you say that your manager made sure there was no camping.
Exactly so.
How is it that we have these photos of camping?
When he left for his trip, and he was due back October 4th, I was in and out, and unfortunately when it came to, October 4th happened, I don't know if they had friends of theirs and they say, oh, just come on over. This is a very unfortunate event, Murphy's Law, and you give some men a ton of land and they just go crazy. I can't explain it. But it was very embarrassing from my last denial. How do you recoup from that? But I'm here to show what positiveness I can hopefully bring to the table.
With respect to the toilet facilities, if I understand it right, there was a toilet facility on 41.
Yes, sir.
But not on 42.
Not at the moment, no, sir.
And I think you said that you have walked from the grow site on 42 to this toilet facility?
Yes, sir.
And how long did it take you to do that?
I'd say about 7 minutes.
7 minutes? Okay.
It's about I did clock it, 0.3 of a mile. But I clocked it, it's about 0.3 of a mile. And I have since put the needed facilities there for the site with a hand washing station.
When did you put the new one up?
It was 2 weeks ago.
2 weeks ago?
Yes, ma'am.
Thank you.
Because I was through the denial process for the other 2.
Okay. Thank you.
Thank you.
Can we go down the line?
Oh, I'm sorry.
Thank you.
I'll question you about lease.
This picture you gave us this morning.
That is from Barnett. It's just
from this surveyor person?
No, that is the environmentalist whom I hired to produce my site management plan. He also helped me with the rebuttal for 42, where you'll see in the packet. He provided.
It's your contention that your grow site is on parcel 42?
Yes, it is, sir. It was.
And your evidence in this piece of paper has some dark red dotted line around it, and it says on the legend, that's the plan area.
If you look through the site management plan, he considered the plan area that area by which I'm focusing the cannabis site area, if you look through the site management plan.
It's not supposed to be a parcel?
No, sir, no. The parcel line depicted is under the grow on 42.
What's the distance then? I don't, there's no numbers on this chart, no scale.
It's in the site management plan. He's very thorough. This is why I was like, okay. And he was out there with the GPS tumbler too. So this is where I would need the surveyor to physically go.
So what are you claiming is the shortest distance between your site? Apparently is in this red rectangle.
Can I approach the bench, or I don't want to do anything
Apparently
wrong?
not.
Okay.
You trip on wires or something. So that nearest point on the rectangle over to the yellow borderline.
Can you
what's
hold
that
the picture
distance?
up so she can see which one you're looking at?
Oh, yes. That to the left side of that parcel line is more than 75 feet, because we were at least 100 feet from the water line, or 100 feet to the parcel line, because we were 75 from the water line for Water Quality Control Board purposes.
Okay, I hear you, but that water line goes all the way around, so that statement doesn't help me. Okay. All right. So back to the lease issue. You say that January 17th was a renewal and you had one before that?
That is correct, yes, sir.
And when was that signed? And was it any different in language than the one we've seen?
The original lease submitted in our application was for May 6th of 2016.
2016?
Yeah.
Okay. And is it the same form as this current one? We've seen attachment 6?
With the exception of the entirety of all those other parcels and this parcel. In the original lease, I believe it's just for an acre on each parcel.
Yeah, I think I remember that from the previous, that was the one you gave us on the previous ones. Is there, do you remember that to be the case, that your previous lease was for 1 acre?
That is correct, yes.
Why did you go from 1 acre to 1,000 acres?
I think, in my opinion, and this is where my relationship with my landlord is strained. And there were some mishaps that happened last year, and I was ready to move. And in doing so, I couldn't because there was no permanent order in order for me to move my site. So the lease had to be redrawn, and it was redrawn. But unfortunately, with it being redrawn, I still had no control over that hilltop area.
Is your brother-in-law here today?
No, but I see his counsel is here.
That's all I have.
In your presentation, you started off with an emphasis on making things right. Just which violations that are alleged in this denial are you contesting that were violations when they were discovered and written up? I'm trying to sort out. I understand you're making great efforts to have things perfect now. Our concern is what was in existence at the time that the findings were made by the administrative agencies, and I don't understand what disagreements you have, if any, with the grounds for the denial having had existed.
Okay. That's a long question. Okay.
I know. Do you understand what I'm talking about?
Yes. So you're asking me generally, what am I willing to make right, which wasn't made right before?
That isn't what I'm asking. I'm saying what wasn't right, and do you disagree with any of the findings as to what wasn't right that the county made?
I had a stellar inspection. The only 2 items to fix were locks on my gates and reflective tape on my signs. And I'm sure you've seen some inspections that have a whole laundry list to clean, but that's all I had. So it was my impression that, hey, I'm doing pretty well. Then the trimmers, with whom I've never used before, just made a mess of everything. Mm-hmm. Of course, they had no vested interest in what I'm doing, what my plans are, but yes, to answer your question. And in terms of, do I disagree with any of the violations, or I was unaware that there was a porta potty that was needed a 1/4 mile or 5-minute walk. That was definitely a need. We did have a hand washing station on 41, but it wasn't up to par for the needs or requirements. I tried to do everything with safety and security, OSHA standards.
I understand, but I'm just trying to get.
Sorry.
I'm trying to get it nailed down exactly. And I understand everything went bizarre.
Awry.
But unfortunately for you, the inspection was made when things were awry. And I am not getting from you any disagreement as to any of the findings that were made that gave rise to this denial. I understand your intention to make things right, and the environment in the county or not the county, I thank you for all the efforts that you're doing to make things right. But we have to deal with what the violations were at the time. And one that I want specifically, if Ben, if you could bring up the picture of the pipe going to apparently the grow that's the subject of. You had one, there we go. Now, is your understanding that where it says grow 2016-402, and I'm asking either one of you, 602, that's actually a picture of the grow?
And it's hard to tell through the bushes there. When I finally found the piping, it did not bury into the garden, as though it was watering that garden immediately.
But it's going at least as far as we see in this picture.
That's correct, where it's cut off, but I couldn't see exactly where the beginning of the grow began. Oh, sorry, go ahead. No.
I'm sorry, I don't mean to interrupt you. Go ahead.
Oh, I just wanted to preface that I was in touch with Kirsten Sheridan. He's the Fish and Wildlife, and he said, of course, asked me, were you given a court order, a citation, or a fee? Why are you contacting me? And I told him, well, I went to the Water Quality Control Board. I expressed to them what happened, and I'm trying to make this right. And I wasn't sure the formality. Is there a specific protocol?
But we're back to making things right. I'm trying to get to what the facts were at the time. To me, it looks like this water diversion line is getting within maybe 100 to 200 feet of this grow, and yet I understand you said you moved the grows from where the earlier grows had been, and this doesn't look like there would have been much of a move to get from the end of this water line to.
If you were to see, it was in your packet, the 2000, when I was denied first for 42, with regards to that, you would see exactly where it would move, making any water diversion, if it were used in 2015, where that grow would be right there. Mm-hmm. So it would bury into that grow.
Okay. So
of course, one might say, well, you could always, hook up another pipe and lead it, but no, I did not use any water diversion.
So as to the water diversion, why you're saying that, yes, there was water diversion, but you didn't have anything to do with it except that you were the leaseholder on property that had the pipes on it.
And I mitigated, yes, sir.
As to the other violations that are part of this denial, do you contest any of those?
Sorry, I'm looking for my, in terms of, sometimes I just go off of the little check marks. I don't contest per se, but I do claim ignorance when it comes to making sure that all the agricultural things, I covered safety, but I guess I didn't cover that part in that I didn't have an immediate porta potty there.
No, I understand. Okay, and just out of curiosity, I know water runs downhill, and I'm not sure how these pipes were feeding grows up the hill. Can you?
Well, as I was climbing, as I was climbing, you would see two pipes that would veer off. I was like, okay, where's this one going? I would pull it, but it was so further up. My only thinking would be that it probably fed those 2015 grows, which were east of the waterway. That was I'm no water specialist, of course. So.
Okay, so the grows on the hill were not being fed by these pipes that were down below them?
Correct,
okay.
Yes.
I just wanted to make sure. Thank you.
Thank you.
Okay, you confused me. I'm sorry. You stated, when Commissioner Wooster was asking you questions, you said that the 2015 grows were 99 plant grows, and you were not there growing during 2015.
No.
You came on board in 2016.
Yes.
And then you stated the 2015 grows were there or not there? When you were growing in 2016?
Yes.
Were they still there?
They were still, like, you could plainly see where the lots were. Is that what you're asking?
I'm asking if in 2016, when you were growing, were the 99 plant people still there?
Oh, no. I was
Okay.
cleaning up after them.
So if that's the case, in the last hearing, I'm having issues putting this together because code compliance stated that there were people up on those upper grows with quads and they came down, but you're saying they weren't there growing in 2016 and code compliance is saying somebody was there. So please clarify that.
No, I believe they're referencing, the one on the quad was Gandhi, and he was going from the water tank coming down. He serviced the water tank coming down.
Who's that?
Just a waterer, a hand waterer. So he was actually my worker, but he came from the water tank, not from the illegal grow up top. So I wasn't sure what Sabrina may have thought, but they use the same road, but he came from...
Okay, but in other statements, you said you had to share the land. You were only able to lease 1 acre, and the land was being used by other people. If they weren't growing with you in 2016 and they were only there in 2015, how were they there growing with you? Do you see where my confusion is?
Yes.
Okay.
2015, of course, I wasn't there. So, the opportunity came up. I started March, looked at the responsibility of what I'm undertaking, what's involved, and that's when I started to grow. I knew I had a problem May of 2017 when I noticed people started going up top.
Okay, so in 2017, there were people there growing not with you, but there were people there growing illegally.
Correct.
And in 2016, there were none.
None.
Okay. So it was 2017 that was the issue.
That is correct, which leads to my denial process.
Okay, and when you talked to Miguel, and Miguel said you needed to call code compliance, or he would call code compliance, you had an inspection with only 2 items that needed to be done. What alerted Miguel to call code compliance and send them back a couple days later? You and Miguel talked.
No, the citation for the illegal grows was previous to my inspection. The excess canopy had been rescinded, but he says you need to bring your site into compliance. You have till September 22nd. I scheduled my county inspection with code compliance on the 21st of September, and they inspected all 3 sites. I'm keeping my sites in compliance, which is, this is what I gathered from Miguel. This is why I scheduled the appointment. So that was before, so citation was issued, my inspection on the 21st, and there was the citation hearing on the 29th of September, and that should have been extended from what I just gathered.
What caused the citation before your inspection?
He said, well, it's illegal, so I'm going to go ahead and issue the citation for the grow on the hill.
Okay, so Miguel called you and said you have too many canopy grows on your property.
Correct.
And you said they're not mine. And
Exactly.
then that's why he called code compliance.
Yes, correct. And that citation was issued on the 12th of September.
And so they handled this as 2 separate issues. On your inspection was different than those.
That is correct, yes, ma'am. And when Courtney came to inspect, he goes, it's kind of funny. Miguel said, oh, she's 1 day early. And I was like, okay. He said to come into compliance, which I am, but, okay. So I have no idea. But he said you have till the 22nd, which is the day that, I was already in compliance, reflective taping and locks.
So are you cooperating with the Sheriff's Department on those 99 plant certificates that you found with a grower's name on them, a registered grower's name for the caretaker?
I can give it to them if they would like.
Okay, I was just wondering if that was something you were doing. And then you indicated that, was it Sergeant Crabtree, you were trying to reach him within a 32-day period and could not. What was the reason that you were trying to reach him?
Non-responsive. Well, he said that we could sit and talk. He could ask me questions. He could interview me and see my side of the story.
Okay.
And that's when my calls went unanswered. When he finally got back to me, November 6th, he said, oh, sorry, I was in training. So by then, there had been already a memo done by Captain Sturm to the planning department to deny me. And then the first sheriff's office report was issued on the 15th of November. So that was when I just, okay, I'll just wait for the denial process. No one's going to call me. They know how to get a hold of me.
Okay. So whenever they put those two code compliances together and they came out and got the criminal is when they tied you to all of it? Is that what you're saying? Well, it was no longer two separate code compliance issues at that point?
This is where everything was just aloof. It was chaotic. I went there, of course, guns drawn on me, but that's okay. I was there 2 days because I'm a responsible registrant to see what's going on my property. And Sergeant Crabtree just said, we're going to take it all. I'm like, what? We found guns. We found this. We found that.
And those guns were found in your shop. That was the photos we seen from the last.
Correct.
Okay. Okay. But that was trimmers.
It was interesting. They found all of that before a warrant was obtained, but that's okay. I mean, this is the information I'm gathering because I don't have much to go off on. Because he verbally said, we found this, and then they're waiting for a 7 p.m. warrant. But I would have loved to speak to a judge who signed the warrant. I would have loved to see how planning or code compliance would have.
Okay, so it's your position at this appeal, forgetting the other two, that you want to keep 41. You don't believe you were in violations on lot 41, but the grow is on 42? 42, 41, wait, okay.
42.
Okay, the grow is on 42, 41's already shut down.
39 as well.
Okay, but the grow on 42 was supposed to be on 41?
No, the grow on 42 is supposed to be on 42.
Okay.
Yes, north
and
of the parcel line.
And it's over the property line?
It is correct. It is lower than what was anticipated. And then, of course, I relied on a paid professional to produce my site management plans, everything needed, and there was an unfortunate event.
Okay. Is there any other questions?
I have a question real quick about the lease. I'm confused about the lease because on 2016, when you leased the property, you leased 1 acre on each parcel, correct? And there was no other growth at that time?
No.
And in 2017, when you renewed the lease, you renewed the lease for all the property, but there were other grows on there.
I was unaware of the grows until May. So by then...
You leased the whole property, the whole 1,000 and something acres, and that's when the other grows were on the property.
At a later point than the lease, which was written in January.
Okay, now I'm confused. The June 27th letter of 2016 from Barnett says that 2 issues came up. It says, first, my client has more canopy square footage located on their property than that allowable by county ordinance, 22,000 square foot per parcel. We have estimated that each of the 1399 plant cultivation gardens is between 8,000 to 12,000 square feet, and then it goes on. That implies to me that in 2016, there were 13 grows there. Is this letter incorrect?
That is correct. We thought we were grandfathered in. The beginning of 2016, I was unsure that we had to consolidate in terms of, we thought that we would propose or do the 3 plots beginning 2017 grow.
Okay, I thought I heard you say earlier that the illegal 99 plant people came in 2017.
That's correct. The illegal plant people on the hill with whom I did not know.
So there were 13 grow sites, not including those on the hill in 2016?
2016, it would include those on the hill. If you see the map that was given in your packet, it shows when I went to apply
the one that was given in our packet from staff or you?
It should be from staff. When I came to apply, I showed the county everything I had. I showed every plot that I had there. And you will see that. I wasn't trying to pull the wool over anyone's eyes. I showed exactly what I had. I also pinpointed which one I was going to utilize for each and every legal grow moving forward.
So how many did you have in 2016?
2016, I had the 13.
You had the 13.
But they were sparse, a lot of disease, but yeah.
Okay, then when the sheriffs went out there in 27, there were what, 8 grows?
That would have been up top. So
Okay, so you're saying you got rid of 10 of yours?
I consolidated 2017 to my allotted 3 legal grows.
Okay. And then the illegal people came in on the heel in 2017 with like 5 more grows? Is that right?
Correct, correct.
Okay, I got it. Now I'm unclear as to which parcel this grow is actually on. I thought you told me it was on 41, according to your surveyor.
On 41, yes, according to, but he was not physically there he just looked at, eyeballed it. And, you know, of course, we're looking at overlays for the county, and I'm actually working with the GIS. On the parcel overlay for the county, it's missing 20 acres. So I have a ticket into the GIS. So I was unsure, like, okay, well, the county says this, let's see what he says. And this was when I was doing all of my informational research. In terms of the lot line adjustment, after discussing with Peter Maurer, I contacted Public Works, I contacted the planning department, and they said, you know, you have no conflicts with any land use or zoning. The lot line is actually a mile long. If it's done properly, you can do a lot line adjustment if this is something you so choose to do. But that would be forward thinking. And
Were any of the illegal grows on plot 42?
No.
Or just yours?
No.
All the illegal grows were on 41?
That is correct, yes, ma'am.
So the one that you're appealing is 42 that had no illegal grows on it, but it was eradicated by the Sheriff's Department?
This is correct, yes, ma'am.
All right. Can we, if everyone's finished with questions, I'd like to go to public comment. Is that okay with you? And
Yes,
before
ma'am. Thank you.
we go to public comment, I think I'd like to start with, we've got staff coming in from Code Compliance, Planning Department, and the Sheriff's Department here. So who wants to go first? Are you just...
Did you pick up the sign-in sheet?
Hi, Sabrina.
Hi there. Sabrina Cable, Code Compliance. Just wanted to state that I did not personally inspect this parcel. I believe Courtney Meinhardt did the compliance inspection on it. But I did do the citation for the illegal grow and was there when the sheriff found all the water lines and all that going to every different grow. And I wanted to state that there was only one central trimming and drying area on all the parcels, and that was on, help me out, Ethan, was that 602?
I believe parcel 41, 601.
Okay, 601. That's correct. So there was only one place where all of these, all the harvesting was going on, and I did witness the quad come down from the top to the harvest area.
Okay. So if she was doing all of the harvesting on 41, but the grow came off of 42, was she written in for a violation on that?
I did not write her for a violation on that. The sheriff kind of took the reins at that point.
Did you have any violations on 42?
I believe, I don't want to speak for that because the fence was down, but I don't know if that was because of the sheriff searching for the runners.
Okay.
All the trimmers that went running, which incidentally I wanted to point out, it was insinuated that they were doing things not by the book by searching without a warrant. We have right of entry on every registered site, so we can go onto any site, and furthermore, if people are running, it's for the safety of employees that we go find them so they're not hiding out doing God knows what without our knowledge. So I wanted to state that for the record.
Thank you. Is there any further questions?
No.
Okay.
Thank you.
Thank you. Miguel, did you have something you wanted to add?
I'm just here to answer any questions you might have. I was the primary planner that was in contact with Ms. Towley throughout this, or the beginning of this process.
Okay, and you're the one that brought code compliance in?
Yes.
Okay.
So if you have any questions.
All right, any questions for Miguel?
Were you here when the appellant was talking about the conversations between you?
I wasn't here, but I did hear him over the feed.
And do you have any?
Well, there's some misinterpretation of the facts on part of the appellant. First off, I never contacted her. She contacted the planning department. I happened to be the planner to answer the phone. She was initially denied on 41 for being for having excess canopy. After she contacted me, she explained that those grows were not hers. At that point, I took a look at her lease agreement. It was only for 1 acre, so she only had control for 1 acre of the parcel. Because of this, I took this to the planning director and explained, hey, she only has control of 1 acre of the parcel. Is she responsible for all the illegal grows that are outside of her control? Planning director felt that she wasn't responsible for that. However, those illegal grows needed to be taken care of. I then contacted the appellant and informed her that the planning director made a determination to rescind the denial. And however, under the conditions that she comes into full compliance within 10 days, with the urgency ordinance, that's when Courtney Meinhardt went to do the inspection on that 10th day. After which, part of the reason code compliance went later on was to deal with those illegal growers. That's when they noticed code violations with the registration side, and everything else kind of just happened afterwards.
Thank you. Any further questions?
No.
Okay, thank you, Miguel. Captain Maceda, would you like to make some statements?
Good morning for about 9 more minutes. Captain Jim Macedo with the Sheriff's Office, and I really don't have a lot of statements. I am here to answer questions. I would refer you to evidence photos that were taken at the time. I believe those paint a picture of what was going on at the time the Sheriff's Office arrived, and I just want to re-note too from my previous statement at a previous hearing. There was a centralized hub that all of these operations, marijuana cultivation sites, were being circulated through. There were water lines emanating, from a centralized well. As the code enforcement officer mentioned, there was a centralized drying station. So it was very obvious to a person on scene that these were all heavily interconnected and intertwined. I'm also starting to notice a pattern of behavior on the appellant that anytime there's any wrongdoing, it was always outside of the appellant's control. It always seems to be somebody else's fault, somebody else's responsibility, and that is inconsistent with what we observed at the site on the day of the search warrant, and that was also inconsistent with the evidence photos that were taken. Thank you.
Thank you. Is there any further public comment?
I'll be really brief.
My name is
Therese Hunkin. I'm sorry? Therese Hunkin is my name. And I am here to read a letter written by Vi's neighbor on the property, Mr. Ken Johnson. He said, I wanted to drop a note and let you know of some progress, at least on my side. He said, I spent a fair amount of time talking with Lai Vaitu'ulala today, and I think we have what will be a really good working relationship moving forward. As I mentioned in the hearing, I like my neighbors, but I am just weary of the out-of-control business on the ranch. In short, if it helps at all, I wanted to let you and the planning board know that if you conditionally approve their third permit, I have no problem with that. Here is my reasoning. We are neighbors who both own our places outright and likely will be neighbors for the next 20 years. They are growing cannabis that is apparently high in CBD and low in THC. While I am truly a rube in this world, I think the CBD is the good substance and the THC is the druggy substance. As such, low THC pot draws far less shady characters to the grow sites than the other varieties. Lai said she was going to be able to have only 1/2 acre grow site if this third permit is allowed, and she would make sure it is well contained. Any other grows would be eradicated by them, probably with the sheriff's help to do so legally, so no repeat of the overgrow this year. Personally, I hate to deny someone their ability to make an income from their property. We all need to make a living.
She would make sure that no one taps the creeks on our side, no one leaves trash blowing around, and of course, the human waste would be dealt with properly. I offered to call her or Freddie, her husband, first with any nuisance issues that we encounter, and she promised to fix any issues personally. Anyway, I am but a small voice in a very complex decision process that you are part of, but I wanted to at least write and let you know that I will not object to the county approving that third permit if you decide to do so. On our end, we just want to be good neighbors, and with the proper controls, we feel we can both enjoy our respective places without disruption from their business interests. Thanks again for all your help in this.
Thank you.
Can I ask you a question?
Sure.
How are you related to Mr. Johnson?
I'm not related to him at all.
Did he ask you to read that?
No, he didn't. I am Vi's aunt. I'm Li's aunt. Li is she's my niece by marriage.
Okay, thank you.
Yes, I asked her if it was okay that I read
just wanted
this.
to know if you had spoke to Mr. Johnson, if he asked you to read that.
No, he did not.
Thank you.
We've got
We
a
have the
copy of
letter
the
of the
record
record.
in our file. It's public. Thank you.
Thank you.
That's it. Thank you. Okay, is there any other further public comment? Okay, seeing none, I'm going to go ahead and close the hearing and bring it back and see if you have any rebuttal you would like to make.
Yes, I do. It's encouraging that the appellant has apparently taken some great measures to mitigate the violations that were found on this and the other parcels. However, that does not change the fact that they occurred while the property was under her possession, which is grounds for denial. To address the water diversion, the appellant claims that she was not responsible for initiating it, and it was the other 2015 growers who she used their sites to grandfather in for the waste discharge permit. But it doesn't matter who initiated the water diversion. If it began in 2015 and the sheriff's office found it actively occurring in 2017, a substantial amount of that stream was diverted. And that is a violation of the Fish and Wildlife Code. And the other two projects that this appellant had were denied due to multiple violations of state and local law, which, pursuant to Calaveras County Code 1795-17082, is grounds for invalidation of this permit.
Okay, thank you. Vi, do you have anything you'd like to?
Oh,
I'm sorry.
The illegal grows on the hill that we've been hearing about, they're not a part of this denial, are they?
If you refer to the aerial image on the screen at the moment, you can see right above the label for 2016-602's registered parcel, those clearings, those were illegal grows.
Yeah, but
that is
are
on
they
parcel
part of the?
42,
Are they
which
part?
is the parcel this row is supposed to be on.
I didn't notice in the record whether any ground for denial that we're currently reviewing has as a part of it the illegal grows.
No,
We're not ascribing
illegal grows
responsibility.
Specifically, no. Perhaps in the other two denials they were, but they would just add to the general violations occurring on parcels under their possession.
Okay.
Any further questions for him? Okay, Lai, now you can come up, please. So this is your opportunity to rebuttal anything that the public comment or staff made.
The sheriff's office wasn't here when I gave my spiel to the sheriff's office, but based on my background check, did I pass my background check? I held a federal clearance for 26 years. I'm fingerprinted by my children's school. I'm a Cub Scout committee chair, fingerprinted. I'm applying for my real estate license. Is there anything in my background which will deem me as a threat to society?
I don't think there's any issue here about the
Okay.
background check.
I figured Captain Macedo was here, he could answer
Right.
questions. But he did state that I'm not I don't seem to be the responsible person. Oh, something happened. No, I'm not taking responsibility. I take responsibility for my 3 legal grows, for making them tip-top shape, which is what they were during my inspections. To follow all hard deadlines. I made all hard deadlines. The deadline for the water board, the deadline for seller's permit, the deadline, I don't believe it's on the urgency ordinance for Department of Agriculture. I have my OP ID. I'm able to lay pesticides accordingly. I had safety and security in mind on all 3 grows. And in terms of that, I just wanted to give you a little background as my rebuttal. It seems like every denial hearing that comes before you, a grower fails to do something important because due to a traumatic event. So I didn't want to bring this up, my last denial, but my father did pass away last year. In fact, this month it'll make his 1-year anniversary. I was in my last year of college getting my bachelor's degree and trying to cope with the shock and loss of my father. It was hard to concentrate on school. I had to finish school or else I would lose all of my scholarship monies. I completed 4 classes in 2 months and received my bachelor's in business management. Another very influential uncle of my husband's tragically passed away at the end of September. We were struck with disbelief and making life so surreal. So this is life, and it happens. It's a matter of how you move on and mourn in the process, and which isn't easy. I requested a code compliance inspection through Peter Maurer, which he said if they approve your grant, if they grant your approval, you may have another code compliance inspection for my 1 registration. I am a cannabis farmer. I sell Tahitian black pearls. For you gentlemen, it's jewelry. And I'm getting my real estate license to allow me to bring good business to Calaveras County. We've lost 2 golf courses. It's very unfortunate for the county's economy. I want to be a stay-at-home mother, able to wake up, drop my children off at school, return to work in my garden, sell black pearl jewelry, and assist clients with their real estate needs, all from home. I don't want to have to drive and put too much unneeded strain on the roadways. In selling black pearl jewelry, the security measures would be identical to that of cannabis, with all safety and security measures required. I see a small strip mall in Calaveras selling these items.
I have to get you back on track.
Oh,
I
sorry.
understand what your visions are for your future, but we have to address what the public and rebuttal was.
Okay.
So if we could pull it back a little bit.
Sure, that's fine. Sorry about that.
No, I understand what you're trying to do, but we have to stay on track with the agenda at hand here.
I made a believer out of Ken Johnson, my neighbor, who physically came here to speak against me my last 2 denials. Great guy. We've formed a better relationship than we've had ever. So please allow me to make believers of you. Hopefully I can make a believer of you, honorable, distinguished commissioners. Please allow me to retain my commercial cannabis registration for Calaveras County. After abatement, with everything gone, I just want to give you the mindset of what I was going through. On 39, I have a pollination room. This is where we get seeds from. And although everything was gone, all of my plants, my hard work was gone, I found just a few seedlings. And if you remember Gone with the Wind, Scarlett O'Hara, how she's digging through potatoes looking for food. Please let me rebuild my terra. That's all I'm asking, for you to believe in me, my capabilities. Thank you so much.
Thank you. Okay, I'd like to, does anybody have any questions? No?
Yes.
Yes.
I do have a question.
Lai.
If I understand it correctly, are you saying that your 3 sites were watered exclusively from your wells?
Yes, sir.
And that you never used these pipes that were discovered
No, sir.
on this property to water anything?
I've got a well that pumps 40 to 50 gallons per minute. And I've got one on 39 that actually I use from April to July during the summer months.
And you're saying you did not put any of these pipes in the creek?
Absolutely not. And just to preface that, The Fish and Wildlife Water Quality Control Board never received any violations on behalf of me, any citations, no court orders. I haven't received anything.
Thank you.
Okay, so I'm going to go ahead and close the hearing and bring it back to the commissioners. Do you have any further discussion, questions?
Well, I have a few things to say.
Well, I bet you do.
With respect to the location of this site, it seems to me it is either on the wrong parcel on 41, which is what the surveyor seems to indicate, or it's bisected by the line between parcel 41 or 42. And in terms of the resolution, it just cites the setback requirement of 75 feet, which I'm not sure covers all the bases here. I think that we're going to have to reference, if we decide to deny the appeal, reference that section of the code, which I don't have at my fingertips, that says you got to be on the site you applied to register for. And we would need to add to the resolution some language that the surveyor retained by the applicant did put the site on, the cultivation area on parcel 41. Also on the toilet facility and hand washing issue, it seems to me the violation is pretty clear there. And I think the resolution should reflect that the applicant at the hearing indicated that the time to walk from the work area to the toilet was 7 minutes. The code requires be less than 5. And I'm not convinced that the water diversion charge has been proven. To me, what she's saying makes sense. Why would she divert water from a creek when she has wells right there to use? And she says she did use. It may well be that those pipes were in fact a holdover from the previous grows in 2015. That would make sense. That's what I'm understanding she's saying. And it's only illegal if it's a substantial water diversion, and that depends on a lot of things, like the volume of water in the creek compared to what's being taken out, and the effect of the diversion on fish or other aquatic resources. And we don't have enough information before us to make a decision, in my judgment, that it's substantial for those purposes. Probably was, but it's not in this record. And with respect to the campsite violation, I don't think there's any question about it. That did occur.
I agree that the resolution should probably have some mention of the fact that it's not on the right parcel. The survey that the applicant gave us this morning has very lacking in basic numbers, and it's impossible to tell just exactly what that means and who did it. If they're someone who's professionally capable of doing it, the only real evidence we have is that presented by the staff, which shows it's straddling or on the next parcel. On the diversion, I do think that she's violated those rules. There's evidence that the pipes were, actual water was coming out of them at the time, and it appeared to be very near the 602 cultivation area. Who knows whether there might have been a pipe that actually led it to it at one point. And in any event, the applicant in 2017, signed a lease January 1st saying she's the lessee for the entire area, over 1,000 acres, that she specifically stated she's inspected it, everything is okay, and that she's responsible for it. I really applaud her efforts to try to clean it up. That's fantastic. But our role today, I believe, is simply to see whether October 4, October 5, she violated as was charged. I believe just every one of these violations has been proven by the county. So.
Well, I was just going to, I can't say I agree with everybody because you guys are disagreeing, but I need clarification as to the water diversion, whether or not it has to be substantial. Is that part of our ordinance, or this is the violation of Fish and Game, or what?
The county's position is that, planning department's position is that there was a violation of Fish and Game Code Section 1602. Mm-hmm. 1602 says an entity shall not substantially divert or obstruct the natural flow of, or substantially change or use any material from the bed of any river, stream, or lake, etc., unless all the following occurs. And one of the things that has to occur is you have to notify the department. But if it's not a substantial diversion, there is no notification requirement and hence no violation.
Well, then what I think we've seen then is that I think the appellant has provided enough, as far as burden of proof, that she probably was not diverting a substantial amount, even though she was responsible for the pipes on her property at the time, since she had the pumps, and I believe her testimony as to the well's capability. So I guess I come to Commissioner Wooster's result, but perhaps it would be just on the basis that no substantial diversion has not been established as of the time of these inspections.
So I need to poll and see where we're at with the water diversion in or out of the resolution. Are you guys, we probably need to get the recommendation going and then make the changes then, but.
Let me respond quickly on the substantial aspect. The applicant showed us pictures of her having removed over 1,500 feet of drip line. I believe it's half-inch drip line or larger. I think that's got to be substantial for that physical area. It's not the Calaveras River, it's just dry creeks, seasonal creeks. That's substantial to me.
So I think that it's clear that there had been substantial diversion. It's not clear that during her time of responsibility for this property that such substantial diversion was being done. There was one picture of one pipe that was spraying, so there's water coming through at least some of these pipes. But we haven't heard any testimony that there was, at the end of any of these pipes, there was substantial water coming out. And so I think that substantial diversion had happened in the past, but I don't see where we have enough proof or enough evidence to indicate that substantial diversion was happening during her stewardship. I think it's a close question.
Well, I think that code compliance came on a day of not announcing they were coming and found these issues. And they did not see the water going to her garden on that unexpected day, which tells me she wasn't using it. That's kind of how I was seeing it. But, if code compliance, she knew they were coming and it was going straight to her garden, I'd say, yeah, no, you were using it. But the fact that they went and she wasn't using it on that day that she wasn't expecting the inspection, kind of tells me maybe it wasn't her using that water. So I guess that would give us 3 votes saying that.
Yeah, well, I think you're probably right if you're arguing that the pipes weren't being used. I disagree with saying that she's not responsible for it if some other person was doing it on the 1,000 acres that she's leasing. So I probably am tending to agree with you, but for a different reason.
Okay.
For the fact that the pipes were not in use except the one.
Okay.
Well, if I'm the landowner and somebody comes on and trespasses on my property and starts diverting water, and I don't know anything about it, I have nothing to do with it, I'm not convinced I violate Fishing Code Section 1602. And I would say that that kind of situation has happened in this county.
Yeah. Okay, so why don't we have him read the recommendation, and then we could make some changes if need be by poll. Or do you want to make changes, suggested changes now, and then he can read as amended is probably the best way to do it, sorry.
And then I have a couple typos.
Okay, well, let's go over those now.
Insignificant compared to what we're talking about. On the second page of the revised resolution, this is as insignificant as you get. You with me, Ben? Okay, near the top of the page, the first line under evidence, employers should not have an apostrophe.
A minute, legal counsel is correcting me in that we should probably.
Do you want to take a vote before correcting the reso?
So it would mean we should make sure that we're all voting up or down on the appeal and then make the changes.
Okay.
Oh, the basic appeal itself?
Mm-hmm.
If you granted the appeal, we'd need a whole new reso.
Right.
Yeah.
What's the question?
So what, are you looking for a motion?
You have to read it so we can vote on it and then change it. Correct?
Yeah.
So let's have him, but see, normally we kind of.
You're the chair.
Let's look at the recommended changes to the resolution before we have him read the recommendation, and then he can read it as amended based on your recommendations.
Okay. Have you caught up to my apostrophe?
I believe that was on the old resolution.
Well, it's one I downloaded last night from you, but if it's not there, that's great.
No, it's there.
Okay. It's there.
Okay, well, on the revised resolution, paragraph 1.
Let me just do another minor one.
Well, that's where your employers
Oh, I'm sorry. Okay.
comes in, first line, take out the apostrophe.
Oh, okay, okay. Go ahead.
Okay, then I would add at the end of that same paragraph, appellant at the hearing indicated that the time to walk from the work area to the toilet was 7 minutes.
She also indicated it's a third of a mile.
Correct. And I would add that too. Or I think it was 3/10 of a mile. I don't have anything more till we get to paragraph 3.
Go right ahead.
You okay?
Yeah, my other thing is on paragraph 4.
Okay, in paragraph 3 paragraph 3, I think we should add whatever the citation is, that you have to have the cultivation area on the site for which you sought registration.
If I could offer, sorry, I'm so used to pulling it up close to me on the table there. If I could offer a recommendation on that, and maybe it should be just a separate finding, is that section 1795-165N3 states, and then that section reads, the registrant must provide evidence satisfactory to the planning director that no later than May 10, 2016, she has taken demonstrable steps toward the development of a commercial medical cannabis cultivation site on the parcel as demonstrated by the criteria described in either A or B below, and by at least one of the criteria described in C through K. And then the statement after that would read, the cultivation area is not on or not fully on the parcel registered by the cultivation under this registration application. And the evidence would be the survey submitted by the appellant's environmental consultant identified that the cultivation site was either straddling the property line or fully on the adjacent parcel. Additionally, the county's aerial imaging, while not a survey, shows that the cultivation area to be on the adjacent parcel. And I would make that as a separate finding.
I think that's very good. With respect to the finding that's there under paragraph 3, the next to last sentence under evidence says, likewise, 2 letters from Barnett Environmental, etc., indicate the area is bisected. I think it's actually only 1 letter that does that. And that's the one to the planning department. The letter to the water board does not say that.
That is true.
That's all the suggestions I have, except, of course, I think that the paragraph that has the Fish and Game 1602, I think, should be deleted.
Well, I have something on paragraph 4. And on the evidence, paragraph 4, where it says, based on multiple aerial images, letters from Barnett Environmental, dated June 27, 2016, and observations made, the word by should be in there.
You probably want observations to not have a capital O.
Yeah. I was saving that for you.
Thank you.
Okay.
Back to Mr. Maurer, what, you have a number for that specific item that you had?
Yes, 17.95.1.
No, I'm sorry, what paragraph number, where do you want to insert it?
I would make it number
At the end, or?
5 and then move, or make it number 6 and then move 6 down to 7.
Which was it, 5, 6, or 7?
6. It becomes 6 and 6 becomes 7.
Is there any further?
Well, so new paragraph number 6, what are we going to do about the water diversion?
Remove the water diversion.
I think that would simply involve the deletion of the paragraph that begins Fish and Game Code 1602.
I agree.
Madam Chair, maybe it would be a good idea to poll the board on whether or not to delete that paragraph in the reference to 1602 first.
Would you guys like to delete?
Yes.
Yes.
That's the cleanest thing.
Yes.
That's 5 votes.
Okay.
Okay? All good?
All good.
Okay, would you like to read the recommendation as amended?
Yes. Staff recommends that the Planning Commission adopt Resolution 2018-011, thus denying appeal, as amended, thus denying appeal 2016-602, thereby upholding the Planning Director's denial of application 2016-602.
Thank you.
So moved.
Second?
Second.
Okay, all in favor say aye.
Aye.
Opposed? So motion carries. Okay,
And this action is final unless appealed to the Board of Supervisors within 15 calendar days from today's date.
and we will break now for lunch until 1:30.
I'll meet you out front. Drive, or do you want to drive?